Hello viewers, welcome back to part 3 of Barbarians at the Gate. This is the concluding part of my documentary series dealing with the wicked depredations and major criminality involving various of the judiciary at Bristol Crown Court and the CPS and the Avon and Somerset Constabulary, and of course security staff at Bristol Crown Court. This deals with the pre-trial, trial, and the appeal stage of matters, just to put the finishing touches to the evidence of all the violence that you've witnessed, all the perjury, all the perverting justice is all rooted in, controlled by, and at the behest of the judges that I've mentioned, Judge Warby on the one hand, who although he deals with civil proceedings, he's made us basically a round robin judicial decision about my character and about my allegations against my wild allegations against other judges. And so he's put in force what's called civil restraint orders, preventing me litigating on any basis. So that if the police knowing that the police have repeatedly falsely imprisoned me here in Bristol over and over again, the same police force, Avon and Somerset Police, and notwithstanding the extent of false imprisonments and assaults against the police involving the same person, in terms of any further false imprisonment and assault allegations, they can't be pursued in the court by orders of Judge Warby because of the civil restraint order put upon me. And of course, so that will show how effectively everything is controlled, so that the police know that when they arrest me, any dealings that they get will be favourably dealt with, that they will get major bias from the local judges, who all have to fall in line with Judge Warby's opinion of me of being making wild allegations and of being a vexatious litigant and that sort of thing. And of course, I've had dealings with these judges myself, including Judge Blair, who initially had control of the case. But dealing with matters in stages, and in some senses, it's fairly petty, because if I'm accusing police and the judiciary already seen in terms of the evidence that they are sexually assaulting me, kidnapping me, perjuring and perverting justice all over the place, then obviously whether I got legal representation at the trial or what venue the trial was in may seem petty, and however deeply corrupt in and of itself that those issues are, they may pale into insignificance if you set them beside the groping and the kidnapping and the perjury, etc., which has all hopefully been proven beyond any possible shadow of a doubt from the evidence you've seen going forward. But obviously it's important for me just to show blow by blow the extent of corruption, and obviously to expose along the way the various individuals that need exposing for the public good, if nothing else. So there is the issue of my legal representation. Obviously, you've seen the extent to which Mr. Ray, when he was appointed to have charge of my case, made a decision, according to Mr. Nelson, around 7 p.m. in the evening, that he wasn't going to represent me because of a historical matter, but he doesn't give any sign of this until he calls the duty solicitor scheme to cancel withdraw his representation at around midnight. So he's by which time I'm exhausted. I've been in custody for 7 hours. And then, of course, the police are then given the opportunity, almost certainly Police Sergeant Harris, to cancel the further representation. So at that stage, there's no quibbling that the police have conspired to prevent any chance of my legal representation, conspired with Nelson Legal, but yet, obviously, there's the next stage of proceedings. I am entitled under Article 6 of the Human Rights Act for representation if I want it, and to have it appointed for me if I can't afford it, or to have it paid for. And of course, that right was then denied me for the rest of the proceedings. And there's some correspondence here that establishes that, if nothing else, the case needed to be transferred to London. Judge Lawrie, who took over the case by orders of Judge Blair, I've already established that Judge Blair shouldn't have been involved, because, of course, he would have known Edward Hetherington, he would have known Henderson Ford, and of course he had a vested interest, and we shall see other evidence of that. Well, we've already discussed the fact that Miss Boreham, for instance, Sharon Boreham, who banned me as a consequence of the incident on the 30th of November with Mr. Ford, a few weeks after the incident itself, and said the judiciary were in cahoots with that decision to ban me on the allegations that were written out as fact by Miss Boreham. So whoever the judiciary were, and assuming them to be Mr. Blair, Judge Peter Blair and Joanna Cutts, because they were the senior judges who had charge of the prosecution in this matter. Then of course they've already established my guilt, or said that they found me guilty based on the letter from Miss Boreham. And then of course Miss Boreham is still the manager of Gloucester as well. That's on the letterhead that she's involved in the Gloucester and Bristol Crown Court venues. So she's actually now becomes a witness in the very case in which she in a court building where she actually works as a manager, and has already found me guilty because of this so-called ban letter, which she refers to in the letter as an order, but it's not an order. She's a civilian, and unless the court makes an order, it's just it's a civilian notification that I will be treated as a trespasser going forward. Even if you just put to one side the whole incident and the connections between the security staff, because of course the office cleaning services were controlled and run by Mr. Ford worked for Office Cleaning Services, who were the same company who operated in Gloucester. The security staff interchanged because, of course, they were from the similar area and they had to stand in for each other. They all knew each other, and I was even told by the security staff there that there was a big photograph of Mr. Henderson Ford as the manager to go to for any lost property in Bristol, and his photograph was all over. Representing the court staff in Gloucester, where the trial again was going to take place. And of course the jury are controlled by the office cleaning services, because the office cleaning services act as the security staff, and therefore they have to chaperone the jury, keep them away from because the Gloucester is a very small building, and you have lots of meeting points where you're physically outside the courtroom, but actually coming into contact with the jury, so that they have to be closely chaperoned by the same company. Again, where Henderson Ford is a witness, the complainant, and I'm accusing of being a thug and a liar and a bully, and violent, criminally violent, and yet the security staff closely allied with Mr. Ford had control of the jury. You cannot make this stuff up. It really does sound like something out of the Wild West. From 200 years ago. But anyway, but as I say, put all that to one side for the moment. There's the simple fact that I cannot get representation anywhere in the Western Circuit. The example of Mr. Ray and his knowledge of me from a previous matter reflects on almost every solicitor's firm who deal with criminal law anywhere, certainly in the Western Circuit, if not the country, because of course Judge Warby has put his decisions against me online as being a vexatious litigant. So any solicitor who puts my name online, for instance, and so will immediately come up as Judge Warby effectively putting a target on me and saying, "Stay away from Mr. Gray, hands off. He's my property. And of course, all the solicitors are complete cowards. They don't say boo to a goose if a judge has a strong opinion about one thing or the other. They just fall in line with that rather than put their head above the parapet. Obviously, you can go to my mission statement and obviously catalogue the fact that the judges are actually supposedly accountable before the criminal law. But again, the fact that every solicitor or barrister owes their career and kowtows to the judges, obviously is another reason why that law is never enforced and is a mockery. We come to the stage where the case has been transferred to His Honour Judge Ian Lawrie, who's the resident judge at Gloucester Crown Court, and he it is who has all the decisions about what will happen to this case now, because as the resident judge, according to the rules, they then appoint which judge will hear the case, which venue, if they have a concern about venue, which is where the court is actually going to be heard, the trial is going to take place at all. That will be decided with the senior judge, the presiding judge, which is in this case is Joanna Cutts. And so these two have the absolute power to ensure that I have a fair trial, and that's why they have those powers. That is their main job, apart, obviously getting justice for the complainants, assuming that they are justifiably the complaints for the sake of argument. Then of course it's still it's the job of the role of Judge Lawrie to ensure that I have a fair trial, which obviously included releasing me from custody, putting me on tag, so that I had to be at home, or I had to be within a certain area for which is called electronic monitorings for most of the for all of the time until the trial, which took place nearly a year later. But I'd already done a month, effectively the equivalent of a month in prison already, because I've been remanded for 2 weeks, which is the equivalent of a month's prison sentence. And the case is now 2021-0023, and this was the case that they went to trial before when Recorder Sellers became the trial judge. But initially, Judge Lawrie agreed that the case should be transferred. I said that I couldn't get representation anywhere in the Western Circuit, and I couldn't therefore be fairly tried, as well as all the overlapping conflicts of interest from the various parties, because the mere fact that Judge Blair had transferred the case and made a collateral decision about how the case was going to proceed, was already a flagrant breach of my Article 6 right, because his decision affected the fairness of the trial. The trial comes under Article 6, fair and independent tribunal, and clearly Judge Blair was not independent, because he knew the witnesses, he knew me. He'd accused me of being a thorn in the flesh of the authorities only a year before, and I in turn was accusing him of being corrupt, because of course he himself found that the prosecution against me the year before in 2020 was illegal, and the prosecutions were acting effectively criminally, but certainly illegally, and yet refused to carry out any investigation, which is the usual recourse for a judge where he's severely criticised the CPS for bringing a prosecution in the way that they had, and therefore bringing the whole of the justice system into disrepute, which is one of the findings that he made. And yet he would not investigate that. And in that judgment, he made took a parting shot at me, saying I was a thorn in the flesh of the authorities. Although the proceedings never transpired before him, I'd never been. I'd been in front of him, I think, in many years before in one matter, but he had no reason to attack me other than he's going along with the lines of Judge Warby, etc., to destroy me because of the allegations I'm making and the evidence I've got proving misconduct of the judiciary, such as Judge Blair and Judge Warby. So the mere fact it's gone before Judge Lawrie has already made the proceedings completely illegal, because there's been no independent control by any tribunal which is distinct and separate from the parties involved in the case. That not only my allegations against the local judges, but of course the evidence that was being relied on coming from security staff who work in the building with Judge Lawrie himself. But then we have the issue of evidence that I cannot get representation, and therefore that is another reason why the case should be transferred, along with the conflict of interest, independent tribunal issues. This is a judgment from Judge Stuart Smith. Now, Judge Stuart Smith is now a Lord Justice, I think in the appeal court or the civil court, but he's one of the most senior judges in the country, second only to the Lady Chief Justice Carr. And when I knew him or came across him in proceedings, references box brackets 2019 EWHC 1954 admin. That was the case of Chief Constable of Avon and Somerset Constabulary against myself. They sought, which is when they sought the another attempt to get an extended restraining order to stop me litigating, so that they can then carry on falsely imprisoning and assaulting and torturing me without any fear of accountability or from the judges or judicial oversight. It's effectively a fatwa. That's what is being enacted by the senior judges. But Judge, for reasons that I think are very shady, but the Judge Stuart Smith refused the application from the police, so that allowing me to litigate, albeit very briefly, because then at the cost of about £50,000, Robert Talalay from the two Essex Court Chambers, I think he's from, is managed to persuade an appeal court led by Lord Justice Irwin to reimpose the restraining order and go back to the status quo ante of police just being allowed to kidnap, assault, torture, falsely imprison, perjure ad infinitum, because I can't litigate and because obviously I'm making these allegations against judges. But before that decision, to overturn Judge Stuart Smith's decision, his judgment stood, and within his judgment, I raised an issue that he should not, he should recuse himself, he should withdraw from proceedings because he had a conflict of interest. Because when I was subject to a prosecution in 2018, I asked for a transfer of that case on largely the same grounds that I was seeking one from Judge Lawrie, which was that not only conflict of interest, but I cannot get representation anywhere in the country. And another senior judge, Mr. Justice Dingemans, who ordered for the case to be transferred to London, was overturned without any explanation. I had a formal hearing in open court where Judge Dingemans agreed the matter should go to London. It was agreed by the CPS, indeed, as well, or the people that represented the CPS, the barrister at the time. I thought that was the end of that. But then I got an email from Bristol Crown Court, Mr. Apps, and Mr. David Apps, I believe his name is, saying that decision has been reversed. The case will now be tried in Cardiff. Cardiff Crown Court was just down the road from Bristol. It has all the same barristers and people that are closely associated with Bristol, in the same way that Gloucester Crown Court did. And I never got to the bottom of why this transfer had been cancelled, the illegality of a decision being made in open court by a High Court judge being overridden without any explanation, effectively by the listing manager, a civilian, was, of course, glaring evidence of corruption and perverting justice. And then, incidentally, I came by the information that it was actually Judge Stuart Smith. So that Judge Stuart Smith, who I was in front of a couple of years later, or a year later, he was at the time the presiding judge of the South East Circuit, so he had control of the London court, and he apparently got on the blower or communicated with Judge Dingeman to put the kibosh on the case going to London. And I'll read you the paragraph in the judgment of Judge Stuart Smith, whereby he refuses to withdraw from the case as him having a conflict of interest. He states, in March 2018, Dingemans J., who was then presiding judge on the Western Circuit, asked me, as presiding judge on the South East Circuit, if I would accept the transfer of a case against Mr. Gray, which involved allegations of breaching an injunction and assault. I was told that details appeared on the Crown Court digital case system, but did not look them up. I was told that there were difficulties in listing the case on circuit, which included that he was not able to find any firm of solicitors or any local barristers to act for him. I was also told that HMCTS, Her Majesty's Court Service, that is, had written a letter banning him from court buildings in Bristol unless he had a hearing listed there because of alleged incidents in the past, and that Mr. Gray was concerned that he would not get fair trial in Bristol. Dingemans J. told me that he had heard the PTPH, that's pre-trial preparation document, agreed that it was a suitable case for transfer off circuit. He said there was a possibility that Mr. Gray may be able to get representation from a firm of solicitors in London, and also that, because of his limited funds, travelling to a Crown Court in London would be much easier for him. I was not told that there was or would be difficulty instructing solicitors in South Wales. In reply, I said that if Mr. Gray was Bristol-based, as appeared to be the case, it seemed slightly implausible to me that London would be the best or most economic location for Mr. Gray's next trial. My immediate reaction was that if the case was not to be heard on the Western Circuit, either Cardiff or Reading would be best. I pointed out that if the case came to London, a court in central London would seem to be the best, but that would be quite a hike from Paddington and not ideal whether Mr. Gray came from Bristol or elsewhere on the Western Circuit. I therefore said that it was not clear to me that the South Eastern Circuit in general, or London in particular, was the right place for Mr. Gray's next trial. Dingemans J. replied with information about bus fares to central London or Cardiff and told me that Mr. Gray would travel to London. He then asked if I would like him to ask the Wells presiders to take this case. I replied that I would. That was the last I heard of the suggestion that the case should come to the South Eastern Circuit. I did not refuse to take the case to be tried in the South Eastern Circuit, though I accept that my response may have had that effect on diverting the case to Wales. So the relevant passage there from Judge Stuart Smith was that he fully accepts that there had been he doesn't make it clear, but there had been an order of Judge Dingemans that the case should go to London. It wasn't something that had been bandied about as a possibility. The issues about whether I could travel there or what my social arrangements were in terms of knowing people in London are not for Judge Stuart Smith, especially without a hearing, to then say, well, I'm going to put my nose so deeply inside Mr. Gray's private life that I'm going to say if the case goes to London, he's going to have to travel there every day. He has no friends or family there that will support him, and of course, in terms of the ease with which I can get to London for a 10:30 hearing, bearing in mind there are mega buses going at 4 or 5 in the morning, it would be no problem at all for me to get to Paddington and walk to central London if I got a 6 o'clock bus from a coach from central Bristol. So the judge is making up all this rubbish about why he wanted the case not to go to London in terms of, effectively taking over my private life and deciding matters that had already been decided in open court. Meanwhile, I had good reasons not to go to Cardiff. The issue about representation that the judge refers to, that I couldn't get representation anywhere on the Western Circuit, he claims he had no idea that we don't have the same barristers from the same chambers in Cardiff, which is just down the road, which he could have researched anyway, given he's going to make his mind up about it without a hearing. It's all rubbish. He wanted the case to stay in the Western Circuit so I could be stitched up by the local judiciary, who are aware of all the issues of my counter allegations and are desperate to silence me by abusing their position of power and trust to rig the criminal justice system in their favour. And that was obviously the thrust of my allegation against Judge Stuart Smith, why he should not be anywhere near a case involving those issues, which are part of the proceedings that he was supposed to be deciding. But even the corruption, proving the extent of corruption from Judge Stuart Smith, and effectively from Dingemans as well, because it was Dingeman who had ordered the case to London, who'd said it in fair hearing, with the agreement of the CPS, it should go to London, that in itself is almost a side issue, because even though it's major corruption in and of itself, the key point there is that it was generally established in 2018 or 2019 when these hearings took place, and when that decision when that comment from Judge Stuart Smith was made, and yet here we are in two more years later, and Judge Lawrie is insisting the case stay in Gloucester, when even the CPS agreed in that case that's been referred to by Judge Stuart Smith, when he was involved in the transfer matter involving Judge Dingemans, that was in 2018. It was established with the CPS that I could not get representation. There was no dispute that it was impossible for me to get representation while the case stayed in London. And there's further evidence from Mr. Graham, Richard Graham, who was he's a solicitor barrister that works in Kent, and he's quite clearly the sort of he's calling him a solicitor barrister. I should explain that some solicitors have what's called rights of audience, so they've got permission from the authorities to actually act as a barrister rather than need to get, because usually it's a solicitor who gets a barrister for trial proceedings. But in this case, he can double up as a barrister, effectively as a barrister, although he is not a fully qualified barrister. But he took on several matters, which again will be issues for other documentaries for another time. But again, in the period 2018 we're talking about, including the case that Judge Dingeman was referring to that ended up in Cardiff, he in response to an advert he made that I applied for from it was called the Inside Time whilst I was in custody to do with the whole Cardiff matter. He agreed to represent me when I phoned him, albeit he was from Kent, and one thing led to another, and he didn't appear. He agreed to represent me because he couldn't find a barrister, and I'll read you his letter in a moment. But the issue was that I was facing further proceedings, perverting justice proceedings, which eventually collapsed on the 4th of February 2019. But before they collapsed, me having to represent myself in those proceedings, Mr. Graham from Graham and Co. agreed to represent me for those and several other prosecutions that were being waged against me by the CPS. And he wrote to me in response to the fact that he'd agreed to turn up, having failed to get a barrister for a hearing to have the case thrown out. It was called a no case to answer, not a no case to answer, but an application to dismiss, which is a technical application that any barrister or lawyer can make before there's an actually the person's been officially arraigned. So there's a brief window where a barrister can step in, and if the case is clearly shoddy and there's clearly issues that the barrister thinks are worth pointing out, have the case discontinued there and then by orders of the judge. And that hearing was eventually listed for the 7th of November. In response to the perverting justice matter, and I'd have finally managed to obtain a solicitor after a decade and a half of trying, and he said he couldn't find a barrister, but he would turn up for the 7th of November hearing, and he failed to do that. And the judge at the time, I forget his name, had to adjourn that hearing and then poured scorn over the email that Mr. Graham had sent, providing his rubbish excuse for having not turned up and offering to do the hearing by way of video link, which the judge said was preposterous considering the nature of the type of application that was being made. And I'd never instructed Mr. Graham by this point. He never took any interest in any of the details of any of the cases he took on. As far as I could make out, and I haven't heard anything to the contrary, he obtained legal aid for 3 or 4 separate cases that he agreed to take on. So probably to the tune of £1,000 or so, maybe a lot more. I'm not entirely sure what he would have got for doing provisional work, and he never even wrote one single word in relation to any of the bundles, the case documents that he was supposed to get thrown out and get me acquittals on and so forth. But I complained obviously his failure to respond. He says that he's responding to my letter of the 3rd of November. I think his date is wrong, but it's inconsequential. It was somewhere around November 2018. And I'll read you what Mr. Graham says in response to my complaint that he'd failed to turn up and therefore he'd sacked. He says in the letter, as you'll see in a moment, that he says that that I was thinking about sacking him. I'd already sacked him by the time he'd sent this letter, but he's responding to the complaint that he hadn't turned up to the hearing. I'm writing in order to give you an update in relation to what is happening with your matter. As you are aware, we had considerable difficulty instructing a barrister to represent you before the Cardiff Crown Court. This matter was adjourned until the 30th of November 2018 in order for us to make an application to have the matter moved to London. I note that this matter was already moved to Bristol Crown Court, and it is very difficult for us to find representation for you. When I say difficult, what I mean is that we have contacted every set of barristers, chambers and freelance solicitor advocates that would attend and represent you. This has been unsuccessful. The fee for perverting the course of justice matter is very low based on the classification of offences. This means that it would not be economically viable for me to travel all the way from Herne Bay to Cardiff to represent you, although this was to be my intention. If the court decided that your matter will stay in Cardiff, then I will personally travel to Cardiff Crown Court and represent you. In respect of your matters before the Bristol Magistrates Court, we have obtained permission from the court to deal with these matters via video link in order for you to enter your plea in respect of the 4 assault matters. In the event that we are unable to find someone to represent you, then again I will travel to Bristol to represent you on that occasion. This is very unusual, and normally I can find a barrister to go anywhere, but for some reason it would appear that no one on that of the side of the country is willing to represent you. Hopefully we can have your matters moved to London Court, and therefore hopefully I should be able to find a suitably qualified barrister to represent you. I know from your letters that you are dissatisfied with the service you have received. I can assure you that I am personally doing everything I can do to try and sort out representation before the Crown Court. I note that you are threatening to dismiss my firm. I would ask you not to do that, because we are generally trying our very best to help you out in a very difficult circumstance. I know that you are really struggling with getting representation. We are hundreds of miles away from where you are, and I'm still prepared to do everything I can to help you out, because I believe in justice and I believe that you deserve to be represented. If, however, you are absolutely certain you no longer want me to represent you, then please let me know and I will close your file. I look forward to hearing from you, Richard Graham. Well, he doesn't even explain why he didn't bother to turn up to the 7th of November hearing, or the hearing prior to this letter, which meant that he'd already been sacked. When I asked him, I said, could you, after he provided this information about not getting barristers to come from other parts of the country, he provided no rationale from if he'd approached so many of these chambers that and diligently tried to get representation for me, the fact that he took no interest in why they were refusing to come and act when they normally would is not explained. So that's glaring evidence it was complete fabrication, that he had no problem getting representation. That wasn't the issue. He was, again, just simply conspiring with the CPS and the police to ensure that I had no chance of any independent representation. And his representation was so bad that he knew that I would sack him. He's pocketed money. If he hasn't got money getting handoffs from the CPS, he's a fool, because he's obviously got, he had to pay money from the orders of the legal ombudsman when they found that he had offered poor service. So he's got in trouble with the legal ombudsman. He's obviously got me on his case for forevermore. But of course, there's no way I could have stood with him if he's not bothering to turn up to hearings, which I didn't need him for anyway, because the case collapsed on the first day of trial, which obviously shows the extent to which it was just more CPS were relying on. If I'd stuck with Mr. Graham, I would have almost certainly ended up being found guilty, if not having the case dragged on for months. He talks about it's not worth his while to take on a case about perverting justice economically, but I was in custody. I've been ordered by Judge Tracy Lloyd Clark. She denied me bail, so I've been remanded for several months, or certainly for a couple of months, several weeks, between the time she remanded me and the case collapsed in February. So he's saying that even if someone's been deprived of their liberty and they're complaining that they've been stitched up and they're innocent of the perverting justice allegations, they themselves are victims of perverting justice, which is my defence. He's got no interest in what my defence is. So he's saying that the economic, the legal aid will actually penalise him. And because he's saying it's not a serious matter, the maximum sentence for perverting justice is life. So how he can say it's not a serious allegation enough for him to merit getting involved, and the legal aid wouldn't pay for him to travel, is madness. Because A, it's one of the most serious allegations you can face, given it takes cost, you get up to life imprisonment, and C, because I was being, for all he knows, assuming you're looking at it from his point of view rather than from the evidence I had, but he hasn't looked at the evidence, so he doesn't care one way or the other whether I'm actually the victim of the injustice that he says he cares about. It's complete Again, I only point out that obviously the massive lies and corruption surrounding Mr. Graham's position, surrounding why he took on 3 or 4 criminal cases and didn't act on any of them, and then didn't bother turning up to a hearing, and then there's absolute fabrication about not being able to find barristers and not explaining. He refused to provide names of any barristers that he contacted to validate that assertion. But that's again the main issue. There is, of course, the fact that I cannot get representation in terms of the hearings and proceedings before Judge Ian Lawrie. Is that you got the two chunks of evidence from the decision of Judge Dingeman's with agreement from the CPS that I could not, the case should go to London because I couldn't get anywhere on the Western Circuit to represent me, and that included in due course Cardiff, when Judge Stuart Smith headed me off at the pass and made sure the case went dashed down the road to Cardiff. And then, of course, I've got Mr. Graham's letter stating in the clearest terms that no one will travel. That when I've finally got a solicitor who's not connected to all the connections surrounding Bristol and Cardiff and Gloucester, then even my name for reasons that aren't given, and Mr. Graham has no spirit of inquiry to find out why en masse solicitor barristers are refusing to travel to represent me against what were clearly serious allegations for which I was already being deprived of my liberty, regardless of the strength of that case against me. But Mr. Judge Lawrie, or sorry, not Mr. Judge, His Honour Judge Lawrie, would have none of it. He said that the case, although he did say initially that he agreed with me the case should go to London, he says no. In fact, I think around May time, certainly, quarter of the way into 2022, he just says no, the case is going to stay in Gloucester. And then, of course, as a sort of hat trick to the 2 other points regarding Judge Stuart Smith's reference to the 2018 prosecution against me, and of course Mr. Graham's letter, again in relation to the 2018 prosecution against me, both glaringly overwhelming evidence that the case should be to add to all the other issues surrounding conflict of interest as to why the case before Gloucester, before Judge Lawrie, should be transferred to London. And of course, there's also the banning letter, so-called, or the banning order as she calls it, of the 28th of January 22, surrounding the incident that is listed for trial at Gloucester Crown Court, surrounding that occurred at Bristol Crown Court the previous November. And in her reference, Miss Boreham's reference to the involvement of the judiciary in that incident, please note that this decision has been made with the full approval of the judiciary following a detailed consultation. The order is made due to a pattern of behaviour at courts across Bristol on the 30th, across Bristol, and then they itemised bullet point one of these incidents being the 30th of 11/21. You attended Bristol Crown Court and racially abused security staff, followed by an assault on same security and on police officers in attendance. I mean, that statement could have actually been, should have been literally pasted onto the sentencing when the person has been found or pleaded guilty to an offence. You did such and such on such and such a day, therefore you're going to get X amount of time in prison. But of course, there's been no trial yet. At this time, the charges hadn't even been fully decided. And yet the judges who had control of the case, and there's only 2 judges it could have possibly been, it was either or Judge Peter Lawrie or Mrs. Justice Joanna Cutts. And if they'd already decided that I had assaulted the officers and racially abused the security staff, then obviously any suggestion, A, that they're impartial, they're completely illegally, if they weren't impartial before, they are now because of those comments from Miss Boreham, and I'm already being decided that I'm guilty of them, and of course they're already even if they had some involvement in that decision and illegally decided that I was guilty when they're supposed to be sending me to trial and being independent and impartial according to the statutory will of Parliament, they already had the conflict of interest in terms of the fact that the security guard that Miss Boreham is referring to is both a colleague of Miss Boreham and colleague of the judges that she's referring to. And Miss Boreham herself then became a witness in the proceedings that because I raised the letter with Mr. Ford to prove how corrupt the judiciary was locally, but when of course the trial had by orders of the same judges, Mrs. Justice Cutts, because she has the ultimate control. It should be pointed out that as presiding judge, she has ultimate control over the venue, as I've just mentioned, so that she had a vested interest in keeping the case in Gloucester in the Western Circuit, so she could then ensure that all the other individuals with conflicts of interest could then be kept within the orbit of Bristol, effectively. By any criteria, because of course the letter is entirely separate. The letter from Miss Boreham is an entirely separate ground as to why the case needed to be transferred to London. On top of the ones, the decisions of Judge Dingeman and the letter of Mr. Graham, all proving that the only reason Judge Lawrie wanted the case to stay in Bristol, to stay in Gloucester, was for the complete opposite of enforcing my rights to a fair trial, but in order to rig the trial in every single way possible to ensure that I was convicted, and that any evidence that I was the victim of kidnap and sexual assault, and indeed at a hearing, even before the judge had finally given the case to Recorder Robin Sellers, I raised the issue at one of the hearings before him in open court and said my defence is that I was kidnapped, and he said you haven't been kidnapped, Mr. Gray. So he'd already decided on the outcome of the trial without any reference to the law of false imprisonment surrounding a breach of the peace arrest and the legality of breach of peace arrest, or the circumstances, or even chunks of the footage hadn't even been disclosed, and the judge by long since held precedent, law of legal authority, is not supposed to express an opinion on one side of the evidence or the other. The whole purpose is to get a jury to decide on the facts, not decide on the facts themselves. But what Judge Lawrie was in fact saying was, you clearly have been kidnapped, Mr. Gray, so I'm going to rig the system in every single legal way possible to ensure that the jury are too dumb, too uninformed, the trial is too egregiously unfair, that's to allow the evidence that you were in fact kidnapped and then sexually assaulted to feature in or be properly considered by the jury, all of which we'll come to when we come to Recorder Sellers. I of course relied and sought to involve what's called non-defendants bad character applications, which obviously was to call all witnesses proving that I've been repeatedly falsely imprisoned and tortured, and attempted murders, strangulations, and all the other abuse, including the formal findings of the various courts that I've been repeatedly falsely imprisoned and assaulted by the police, and ergo I was entitled to use self-defense in any event, and so forth. And Judge Lawrie refused to have a hearing in respect to what evidence I was allowed to bring into court to show the jury. And even though he wasn't going to be the trial judge, and none of the substance of the case was ever discussed in front of him, he made a decision without a hearing, just emailed me to say he's not going to allow any of this evidence in. So all the evidence surrounding all the other injuries from the police and all the witnesses surrounding even the witnesses within this case. So I wasn't permitted to call Police Sergeant Harris, for instance, to question him about the legality of my being detained and not interviewed, or being denied representation, and Tayyip Hussein, who had control of the investigation, he was the senior investigating officer in surrounding all the disappeared evidence that wasn't disclosed. All those witnesses were refused by Judge Blair, albeit most of them would ordinarily in a fair trial be called by the CPS themselves, because it would be expected that I be wanting to call them anyway, and that they want to ensure a fair trial if they're aware of what the allegations are police misconduct. In terms of just the technically how illegal Judge Lawrie was being, it states clearly at Part 21 of the Criminal Procedure Rules 2010 and the Criminal Procedure Rules of what the rules that the judges have to abide by in order to comply with the basic provisions of ensuring fair trial for people that are accused in the UK, also England and Wales courts anyway. One of the rules are Part 21.5, the court must announce at a hearing in public the reasons for a decision A to admit evidence as evidence of bad character or refuse to do so. Judge Lawrie gave me no hearing at all, so he clearly entirely ripped up Part 21.5 about having to state and give his reasons as to why he was going to refuse to allow me, for instance, to call the officers in the case, the senior investigating officer or the officer responsible for my being interviewed without police conduct. And we shall see in due course that much of the statements given by these same officers were relied on even by Lord Justice Fulford when he refused my application for appeal. So the police officers' custody record notes are treated as gospel writ and as factual, even when they're contradicted in many cases by each other or by footage and so forth. Even though the judge refused to allow me to call these officers and actually question their evidence in open proceedings. There's another rule that Judge Lawrie just completely rips up because he's not interested in the rule of law. He just wants to get me convicted by all costs, by any means necessary. And he states one of the rules he's broken is Criminal Procedure Rule 2020, which states 21.34, a party who objects to the introduction of evidence must A, serve notice on the court officer, and 2, each other party not more than 10 business days after service of the application, and B, in the notice explain as applicable the reasons why they object to what evidence the other party is seeking to introduce as bad character. Because Judge Lawrie didn't made his decision that none of the material of bad character was going to be permitted without a hearing, as he's giving his reasons to do so within the other criminal procedure rule, he also flouts the rules that he thereby completely excuses the CPS from providing the reasons as to why they object to such evidence being produced, whether it's injuries that I've received from the police and therefore could not be more relevant to self-defense, pleading against violence from police officers during an arrest, and obviously officers involved in the investigation, etc. The whole point of them having to respond is obviously because the judge, again, is supposed to be independent. It's not for him to decide what evidence is or is not, should not or not be allowed. Until he's heard submissions from both sides, but he doesn't make up his mind as if he's already decided what the case is going to be. But all he's doing, he's flouting the requirement of the CPS to respond and set out their position independently as to what they say should be allowed and shouldn't be allowed. Again, he simply wants to suppress any scintilla of evidence that I have been the victim of crime and misconduct from the police and the perverting of justice and all the skullduggery that we canvassed surrounding the denial of representation, the skullduggery with Mr. Ray, the disappearing chunks of the CCTV footage so that Mr. Ford can pretend that he was being polite, the sending off of the SD card so that all the verbals and the footage of, again with Mr. Ford, could be disappeared, etc., etc. That's all Judge Lawrie is concerned about. So there's no rule that he will not break, no law that he will not flout to achieve that end of the stitch up. And indeed, it's almost certain that Judge Blair, it's evident on what came afterwards, but Judge Blair clearly, apart from anything else, apart from all the conflict of interest and denying me legal representation, etc. He must know that Judge Lawrie is about as corrupt as they come, and it probably has a reputation amongst other judges as being really the bottom of the pile in terms of when it comes to being ruthless and violating every single right a basic defendant and so many people have died and sacrificed their lives for. So we come on then. We deal with the major illegalities where I'm being hung out to dry in no uncertain terms, in terms of thrown before this absolutely merciless, ruthless, and venal judge, Lawrie. And he's even aware that my allegations involve a conspiracy, effective conspiracy between former judges and present barristers and former barristers, etc., of 2 KBW chambers. That's in a defence statement that's provided only a few weeks before to Judge Lawrie. And who does Judge Lawrie pick as the trial judge? The now Judge Robin Sellers, but at the time a barrister, not a silk, so he was even a lower level barrister compared to a silk who's at the top of the game, if you like. Again, because who's going to have the most vested interest in getting me convicted and suppressing evidence of misconduct, or that I'm a victim of a conspiracy concerning 2 KBW chambers barristers and judges? Well, it's certainly who do I get? It's another 2 KBW chambers, effectively proving the conspiracy and the icing on the cake as far as the skullduggery that Judge Lawrie is prepared to do so. All the time actively suppressing evidence of the most heinous criminality that's been canvassed in the earlier parts of these videos. So the final stage is, of course, the trial itself and the appeal. And I'm not going to relive and force you to relive the blow-by-blow descriptions of the skullduggery during the trial that was between the 16th of October to the 4th of November 2022. There's a few pointers to make. Obviously, as the video showed exactly what had occurred between myself and Mr. Henderson Ford, which was obviously the foundations of all the further proceedings and arrests and responses to being arrested, etc., flowed or was built, but Mr. Robin Sellers, as we'll see in a moment, in terms of his summing up to the jury, managed not to indicate what he'd actually seen, what the footage actually showed. He gives descriptions as all the various conflicting statements and from the various parties, but barely at all does he canvass. He may have referred to the clear evidence of the fact that the sound recording proved that I never said my people and dying for your people and this rubbish was not said. He might put it neutrally, like he couldn't be heard on the footage, as if we're whispering to each other. Apart from that, all he would have to have done at any stage is look at what the footage actually shows, dismiss the case, have an investigation into the officers and Henderson Ford for the kidnapping and sexual assaults against me. But as indicated from the outset, the police know exactly what will happen at the outcome of all these ordeals that I'm facing. They will make sure that the judiciary, who have as much interest or more interest than the police I accuse of wrongdoing, to use all the power at their disposal to shut me up and ensure that every fragment of my basic rights to fair trial will be absolutely eviscerated. So that instead there's absolutely venal, outrageous fabrication of that I'm the instigator can be sold to a jury, who themselves are selected by, chosen by the Gloucester Western Circuit officials. And here's what all I really need to tell you about the trial, as if I need to, which I hopefully don't, go into any more depth as to why the proceedings before now Judge Robin Sellers was a travesty. So thankfully I don't have to revisit and relive the entire trial proceedings. The summing up that Robin Sellers gave to the jury lasted about an hour and a half. Not once or in passing did he refer to the existence of footage at all. He didn't refer to the missing footage, which obviously was the key point of my my complaint, that the trial was unfair and that I was the victim of misconduct. But what the footage was shown, the GoPro and the CCTV, etc., and the body-worn video was never recounted and never relied on in Recorder Sellers' summing up. And I'll go through his what's called a no case to answer ruling, which is an application that the defendant is allowed to make halfway through the proceedings before he or she gives her own side of matters, and the matter goes before a jury. After summing up and closing speeches from the parties. An application can be made that there's no case to answer enough to go before a jury, and the judge should throw it out there and then. It's also known as a Galbraith ruling, because that's the authority that it most relies on in terms of what the judge has to apply to consider whether or not a case should be dismissed at that stage. In my case, obviously, I had all the footage to rely on, and if I'd been before a fair judge, I would have been the victim. I would have been and the others would have been the suspects and the defendants. But in the nature of proceedings I got the decision I got from Recorder Robin Sellers, and I'll read it out before I come back to where it's gone wrong. On the 11th day of trial, the 1st of November 2022, Mr. Gray made an application under the second limb of Galbraith that I should withdraw all counts from the jury. He accepts that there is evidence of the elements of the offences that he is charged with established in the evidence, but he goes on to assert that the evidence is of such vagueness and tenuous nature that the matter should go no further due to inherent weakness. Well, no, I alleged perjury and perverting justice, so that already Robin Sellers is lying his head off about what my actual grounds of my application were, because obviously where there's evidence of perjury, that's not inherently weak, that's a criminal offence in its own right. But nonetheless, Robin Sellers goes on. In the course of his submissions, he makes the following complaints: that the Crown have never particularised the case against him such that he knows what to meet, that the Crown has not engaged with the issue of self-defence. I interpret this to mean that he feels that there is insufficient evidence to rebut the same once he has the punch and the spitting that he accepts carrying out did occur, that there has been a failure to consider his counter-allegations, that the Crown has not discharged its obligation to carry out reasonable lines of inquiry. This seems to be another articulation of the counter-allegation point, that there are ample examples of vagueness in the Crown's evidence, including what he considers to be changes in testimony. I have invited a response from Miss Constable for the prosecution. She has taken some time to set out the Crown's case to address Mr. Gray's fear that this has not yet happened or had not happened sufficiently. In relation to count 1, she asserts that the behaviour of Mr. Gray as shown on the GoPro footage that was seized from him raises a prima facie case in terms of abusive and insulting behaviour. Count 1 is the racially aggravated public order, section 4A charge, I should just add. In terms of abusive and insulting behaviour, including calling Mr. Ford a tyrant. She further goes on to state that the repeated shouting of the words Idi Amin satisfy the racial hostility element of the offence, given his black heritage. In relation to counts 2 to 7, which are the punch to DS Bale and the spitting at various officers, she asserts on behalf of the prosecution that although self-defence has been raised by Mr. Gray, the circumstances of the case are sufficient for a jury to infer that the defendant did not think that it was necessary to use those violent acts, and that the type and level of force was not reasonable in the circumstances. Fundamentally, she calls Mr. Gray the aggressor. Whilst Mr. Gray states that he is in the dark about this aspect of the case, I find that the renewed exposition of the Crown's case is entirely unsurprising and has not departed from the opening. In terms of the point raised as to Mr. Gray being the subject of a kidnap after an unlawful arrest for breach of the peace, there is, in my judgment, ample evidence from which the jury could conclude that DS Bale reasonably apprehended a future breach of the peace, including violence, if Mr. Gray were not suitably contained. He relied on Mr. Gray's confrontational demeanour, refusal to leave the premises, the use of racist remarks, and his volatile mood that made DS Bale feel intimidated. As far as the element of vagueness is concerned, I invited Mr. Gray to give some examples, and he listed D.S. Bale's confusion over where the punch landed, not that it was administered. That D.S. Bale and D.S. Edgeworth, thought that Mr. Gray was complaining of sexual assault at the hands of D.C. Warren as opposed to D.S. Bale, and that there were inconsistencies in Mr. Ford's account, in particular to the use of the phrase "you people," as reported in his witness statement, which is not easily discernible in the GoPro footage. Standing back, I have applied the approach to the submission on the basis set out at para 1659 of Blackstone's criminal practice, which states, if there is no evidence to prove an essential element of the offence, a submission must obviously succeed. This does not apply in this case. If there is some evidence which, taken at face value, establish each element, the case should be left to the jury. If the evidence is so weak that no reasonable jury properly directed could convict it on it, a submission should be withheld. Weakness may be from sheer improbability, from internal inconsistencies, or evidence of a doubtful nature, such as identification. The question of whether a witness is lying is nearly always one for the jury, save whether the inconsistencies are so great that any reasonable tribunal would be forced to conclude that it would not be proper for the case to continue. Having followed that path of reasoning, I remind myself that this is a case where the primary facts are accepted. Mr. Gray states that he wasn't threatening and abusive, nor racist in his comments, and although he punched and spat, he was acting in self-defense. It is correct that the prosecution have the burden of rebutting self-defense, but whenever that defense is raised, it almost always pushes the case towards the ambit of the jury to decide the relevant two-stage test in relation to necessity and the use of reasonable force. I am also aware that the Crown need to satisfy the tribunal of fact as to the legality of the arrest. In my view, there is prima facie evidence from which the jury could conclude that it was a lawful arrest. There are inconsistencies in some of the evidence in the case, but I do not find those to be of the magnitude that I should step in to withdraw the matters from the jury. Nor do I find Mr. Gray's allegation of lying that have been put to the witness so irresistible that no reasonable tribunal could come to another conclusion. Well, we can see, ladies and gentlemen, first and foremost, glaringly, no mention of what the footage shows. The whole point of the no case to answer is the stronger the evidence, the more weight should be given by the court as to whether or not there is a case to answer. The issue about Mr. Ford's conduct, stating that he's polite, that's clearly proven as bold-faced fabrication from the footage itself. The disappearing footage already means that Robin Sellers has had to collude in the connived in the concealing of evidence in order to divert an investigation from its proper course, because he knows that the first 10 minutes of the CCTV exchanges between myself and Mr. Ford, which are referred to clearly as being seized in the MG5 statement, have simply vanished and never been disclosed and been edited out from any consideration by him or the jury. The same applies to the CCTV in front of where I say that I was sexually assaulted in front of those officers. In order to rebut self-defense, or to say that there's not a case to answer against those officers, that Recorder Sellers has already connived in even the perverting of justice, getting rid of the offence, never mind the offences that can actually be seen unfolding on the camera. The Section 32 sexual assault, the foundation of my sexual assault allegation, even if I was being lawfully detained, is completely ignored by Robin Sellers, because he doesn't indicate what is on the footage showing the degree of caressing that I'm being subjected to by Mr. Bale, and the actual statute that clearly says the lack of any evidence that I'm engaged in something that would give the officer reasonable grounds to assume that I was going to cause serious harm to myself or others. The listing of the conduct that the judge, he was Mr. Sellers at the time, but now obviously Judge Sellers refers to, he says, Mr. Gray, he said I needed to be suitably contained. It was effectively like a virus. And basically what he means is deprived of my liberty, shackled, taken and locked in a toilet in Patchway. And he says that because these are the reasons why he says that a British subject should be to be detained, i.e. arrested and detained and taken to a police station. He relied on Mr. Gray's confrontational behaviour. Well, apart from the fact it was Mr. Ford who confronted me, I did not want to engage with him at all. Apart from the fact that he's lying about the fact that he was polite. He lied about the fact that I put the camera in his face when he can clearly be seen doing the same thing to me with his mobile phone, but I do nothing of the sort in return. The refusal to leave the premises. Well, these are the Crown Court buildings, public property, owned by the public at large. They're there to serve the public. I'm a member of the public. He's saying merely on the basis that Mr. Ford or some of the officers didn't want me there meant that it was lawful for them to rob me of my liberty because I remain in the public building that is supposed to represent my rights. The use of racist remarks. Well, we've established that whether or not I use racist remarks may be a matter for a jury at some point, but the issue was that at the time I was detained, the officer had no evidence that I'd used racist remarks. This was an allegation that they initially didn't want to detain me for at all, and didn't fall under breach of the peace anyway, because that was we'll come to the breach of the peace in a moment. But the volatile mood, what is that? That is completely meaningless. These are at the very best subjective beliefs of a particular officer that have no bearing under the law of Laporte and Howell, that the law lords have set out and clarified why and when a police officer can detain someone and deprive them of their liberty under breach of the peace powers. None of them have been described there by Judge Recorder Sellers at all. He's taken no interest in setting out what the breach of the peace powers are, and that has to be established or cleared up before the matter goes before a jury, or before I should even be considered for being charged, because obviously if I'm acting in self-defense, it's the offences, the criminal violent offences, that the other party should be investigated and prosecuted for. Then we deal finally in terms of addressing the no case to answer, which, as I say, covers pretty well everything in the trial. He states, and this is at paragraph 6 of his judgment, there is, in my judgment, ample evidence from which the jury could conclude that D.S. Bale reasonably apprehended a future breach of the peace, including violence, if Mr. Gray were not suitably contained. Well, leaving aside, there's no suggestion the violence doesn't have to come from me. He just says that the violence may be a product of my remaining in the court, i.e. from Mr. Ford. But we can see from the witness statement, we've established both in the witness statement and the MG5 statement that I was arrested and detained because I committed a breach of the peace. The fact that the police officer Bale got onto the witness stand and changed that and altered that to say it was to prevent a breach of the peace was simply Judge Sellers colluding in the fact that Bale was having to contradict his original reasons for detaining me in order to somehow legitimize and legalize my arrest, albeit that if someone's arrested to prevent a breach of the peace, it's actually a completely different criteria, and it has to be, it specifically states in the wording, it has to be an immediate fear that the person will commit an immediate breach of the peace, which couldn't be applied to myself. But even if that may be a legitimate reason to detain someone in my circumstances, which it clearly isn't for the reasons that I've stated, in particular to do with the officers colluding with Ford's conduct and the fact that it was all filmed and could have been checked. It doesn't matter, because all that matters is my state of mind at the time, reacting to whether or not at that time I was being illegally detained, and whether or not I was being legally detained was based on what I was told by Mr. Bale was the reasons for my arrest, which I was being arrested for a breach of the peace, which meant that there had to have been an incident of violence or threatened violence in order for me to be arrested for breach of the peace. That clearly doesn't apply to somebody arrested to prevent a breach of the peace occurring in the future, because then the officer doesn't have to prove that there has been violence at that particular second. It has to be immediate. There's about to be threatened violence or violence, which again would be hard for the officer to prove without any evidence that somebody has actually committed violence or threatened violence. But in my case, it had to have actually occurred in front of the officer, none of which is described by the officer or described by Robin Sellers. So all he's doing is cataloguing, and not only that, because as we should come to in a minute, we come to the appeal, which was turned away on paper, and because I've been unable to get representation, which will be the very final stages of this documentary, effectively, between Robin Sellers and Lord Justice Adrian Fulford, they've completely overturned all the High Court rulings on legal grounds of arrest. If my behaviour, and it's important to stress that civilians have as much power to arrest under breach of the peace powers as police officers, the kind of standards of behaviour or the types of behaviour described by Robin Sellers as grounds for my being suitably contained, i.e. arrested, have been lowered to the such that there's any conduct that any former person, it's completely removed the Laporte ruling that there has to be evidence of threatened violence or violence itself, to simply not leaving a public building, or the other reasons given, being confrontational. Even when so I'm surrounded by officers in masks, and I'm the one who's accused of, as a civilian, of being confrontational. But it means any argument in which you're feeling in the right or being potentially oppressed by people in authority would be described as confrontational. Arguing with a friend to a passionate degree about a football team could be seen as confrontational. It's any kind of conduct that Mr. Sellers is now saying it can replace the ruling, the law lord's ruling of Laporte in terms of violence or threatened violence, and of course the historical allegation of the racist remarks. As at the risk of repetition, we've already clarified that an officer cannot arrest somebody for conduct that may or may not amount to a breach of the peace, which they've heard about third hand. It has to be happening in front of them as the matters are unfolded. So when we came to the summing up by the judge, by Recorder Sellers, or now Judge Sellers, needless to say, it was a replica of the, much more long-winded, but in terms of the essence of the complete lies and whitewash of the no case to answer ruling, it was identical. It simply, Recorder Sellers simply bombarded the jury for an hour and a half of detailing almost every verbal account, obviously missing out key issues, but the various versions given by Mr. Ford and officers Doxey, Bale, etc., without any reference to what the video actually showed that had been viewed over and over and over again throughout the proceedings, in particular in front of Recorder Sellers himself, but they are of no interest to the essence of the case against me that is set out by Robin Sellers, and of course my grounds of defence handed down, or relied on. So the jury, God knows where they came from. Obviously, it was a matter for them and their conscience to find me guilty, because they had seen the footage, they had seen the endlessly fabricated evidence, the disappeared evidence, and of course, it's worth bearing in mind how not only were they being chaperoned and supervised by colleagues of the complainant and clearly thug Mr. Ford, but of course, the more evidence I provided, the more glaringly obvious it was that I was being subjected to a judicial conspiracy. The members of the judiciary were in cahoots against me and allowing all kinds of major violence to occur against me, including obviously in relation to this case, but not specifically to this case, because there was a whole load of background other incidents where I had been falsely imprisoned and assaulted by the police that were recounted in the most briefest terms by Recorder Sellers. I wasn't permitted to show actual documentation or formal findings or decisions. There was simply passing reference to the fact that I had been repeatedly falsely imprisoned and assaulted. It was accepted by the CPS, but no details were given. But of course, the more glaringly obvious it was that there was various of the senior judges in Gloucester and Bristol wanted my blood. Of course, the jury would be terrified and intimidated by that. Robin Sellers often shouted at me when I was trying to give evidence under oath. And of course, the whole nature of the case was that if I was being kidnapped, then clearly the jury themselves were being kidnapped, having to decide on a trial when I was whether I was guilty of an offence when I was clearly the victim of egregious sexual assaults, kidnapping, and the such like, all of which could be clearly seen. So, ironically and terrifyingly, of course, the more evidence I had that there was corruption, that the judiciary were literally out for my blood, and were certainly allowing any form of criminality to unfold against me, to act in their interests, then of course the jury would be aware, because they're all local citizens of Gloucester. And of course, they don't know if they're going to have need the involvement of the police. The Gloucester police are notionally separate from the Avon Somerset Constabulary, but of course there's lots of interaction between the two because they're neighbours and they're only a few miles apart. But in terms of the judiciary, in particular, of course, it was, the amount of corruption was glaringly obvious from. In terms of Ian Lawrie's involvement in the case, and of course, and I mentioned Joanna Cutts repeatedly. So of course, quite literally, the jury would be terrified of that they're going to get a knock on the door. They're not, if they're being forced to take sides. Then are they going to take my side and therefore put their heads above the parapets and obviously effectively find that the judge was corrupt, because that was the basis of my defence in essence. So it was, again, this is just this is more evidence that within, certainly where I'm concerned, and obviously I'm absolutely certain other people as well, but within the Bristol Gloucester little few square kilometres, there's effectively a mini tyrannical state. When I'm calling Mr. Ford a tyrant, of course I was referring more to the fact that he's a tyrant on behalf of other tyrants that have an interest in him being allowed to attack me and terrorise me from the entrance, from even existing within the confines of Bristol Crown Court. So of course the jury would have been terrified that they too would be sucked into the maelstrom of evil and corruption and terror that I was being subjected to. So that needs to be considered. That was, of course, another reason why the case should be transferred. And of course, given all the complainants were members of the Avon and Somerset Police, with the exception of Mr. Ford, effectively the Gloucester Crown Court became a police station. It was simply surrounded by and full of Avon and Somerset Police, all claiming that I was the culprit, and again, sort of intimidating the jury when apart from anything else, they too would come in contact with the jury because they're coming in and out of the various doors that interlink. So that needs to be borne in mind as well. But so I was found guilty, and Recorder Sellers imposed a 18th-month prison sentence on me, which was the combination of the totality, it's called in legal terms, of all the individual charges of assaulting Mr. Ford and racially abusive Mr. Ford, and the assaulting emergency workers. The individual sentence included 18 months just for the calling Mr. Ford a tyrant and Idi Amin, and another 10 months for splashing water on Mr. Bradshaw, the detention officer, because there was a racial element to the charge. The charges, it meant that instead of being released on tag or considered and normally getting tag a quarter of the way through the sentence, and then being released from the tag at the halfway point, so you continue the custodial element of your sentence in most cases under 4 years, at the halfway stage of the imprisonable part of the sentence. Because of the racial element, I had to do an extra 3.5 months because I couldn't be released on tag or considered for tag because the powers that be involved from probation, presumably handed down from the Ministry of Justice, that they treat racially aggravated offences, even verbal abuse, more seriously than they treat violent offences. And violent offenders can be released unless there's a bladed article involved. They can be released at the quarter of the way stage, even if that's beating up your girlfriend or and so forth. But simply verbal abuse or verbal insults is treated more seriously than actual physical violence within the probation guidelines as to when, or rules as to when you can be released as part of the custodial element of any sentence under 4 years. It doesn't apply to sexual offences, as I say, and it doesn't apply to bladed article or racially aggravated offences, even if the racially aggravated offences involve no violence or suggestion of violence at all, which is obviously the case with myself. So, included in the sentence, Robin Sellers also made me subject to a restraining order, which means that if I breached the restraining order, I could face up to another 5 years in prison if convicted for that release, for that breach. Which included not contacting Ford and not entering Bristol Crown Court unless it is for specific purposes of a hearing in which I'm a witness or a defendant, which is probably what they have in mind most of all. Of course, the contact with Ford is not much of a problem, considering I'm in terror of this man, not vice versa, and of course his fabricated, yet further fabricated allegations. But of course, the banning of the Bristol Crown Court should obviously be either total, notwithstanding it shouldn't be existent, because the trial was not even a mockery. It didn't even qualify, in my view, as a show trial. It was so brazenly corrupt on every single element that I won't bore you with by repeating. And if haven't convinced you of it by now, if you've watched even some of these documentary videos, I never will. But of course, the banning of the Bristol entering to Bristol Crown Court should either be total. The idea that I'm supposed to walk the gauntlet of going past Mr. Henderson Ford, who I'm not supposed to communicate with, when he's the security guard manager, so the most senior security guard there, who I presumably I would be allowed to complain to if I was being mistreated by other members of the other users of the court building or other security staff, is patently preposterous. And of course, what Mr. Sellers is actually trying to do, or Mr. Sellers as he was called then, is to obviously put even more terror, even more prejudice on my having any fair hearing in any respect, in any kind of case, even when I could potentially, in theory, be the victim. Of entering a court building, in which I could face 5 years in prison just for entering, and then another 5 years for communicating with the security manager at the in charge of security at a building in which I'm well known and apparently, according to Mr. Ford, volatile. That was the trial and sentence before Recorder Sellers, which naturally I attempted to appeal, and the appeal has two stages. First of all, it's in writing, and the judge looks at what's called a decision on the paper, and then decides whether there's grounds that he or she, in this case it was Judge Fulford, so let's call him he, can then refer to the full court, as it's called, where it goes before usually three judges, including a law lord, although at the time Lord Fulford was himself a lord, and then the court then decides whether they can allow the appeal or quash the conviction, or order a retrial, or quash the conviction and order a retrial, or quash the conviction and that's the end of the matter, or they can refuse the appeal, and they can ask you to, and then they can order you to serve more time if if you haven't served out the rest of your sentence by the time it's heard from appeal. And of course, I'll come to it in due course, but Fulford's refusal was challenged initially, and I thought that I might be able to have the hearing after my sentence date had expired, and therefore they couldn't send me back to prison. But once it became clear that they sped things along to ensure that they did have the power to send me back to prison if they refused the appeal, I said no, and I withdrew the appeal as I was entitled to do. But obviously, in the meantime, I've tried to get legal representation since my sentencing, and since I was carted off to prison. I attempted to get legal representations, and that's a whole new, whole separate issue that needs to be dealt with in terms of the appeal progress, or if you can call it that. But let me deal with what Fulford has to say. Now, Judge Fulford is an interesting choice of judge to get. And I should point out that I corresponded with the registrar of the Criminal Appeals Office in London, and her name is Alex Beldam. And she's just called simply the registrar, but she effectively has case management of appeal submissions. And as you can probably guess, most appeals are dealt with after you've received advice that you should appeal from your counsel. But of course, I wasn't represented, and one of my grounds of appeal was that I was refused access to legal representation. It's an Article 6 human right that anybody who's accused of an offence is entitled to legal representation by statute. And of course, we've examined the extent to which I was denied legal representation at every stage, both from the moment of my arrest all the way up until I was before Judge Lawrie. And I've shown you evidence about, from Richard Graham saying that no barrister would come from any part of the country to represent me that he knew or contacted, although he didn't provide me any names or any reasons for barristers saying that. And we have the judgment of Stuart Smith, Lord Justice Stuart Smith, as he's now called, providing absolute nonsense as to why he kiboshed the decision of Judge Dingemans to transfer the case, a previous prosecution against me in 2018, to London. So I contacted Alex Beldam once I submitted my appeal grounds, and I said, I'm making all these allegations against other judges, including Judge Stuart Smith, including obviously Lord Justice Warby. I'm saying that I'm the victim of a conspiracy that's led by the senior judiciary in the High Court, such as Judge Warby in particular, although he's not by any means the only judge or anything like, but he's been in the fray. He's been in the mix, as it were, for the last 7 or 8 years, and he's the one that's put in the most draconian orders to prevent my litigation on request of the police, who have repeatedly falsely imprisoned and assaulted me, even by the findings of the court, and in some cases their own admission. So obviously I was entitled to say that within my Article 6 right to an independent tribunal at the appeal stage, could you give me some indication of how you're going to select the judge that won't have a conflict of interest, that won't know Judge Warby? And I didn't even know at the time that Judge Warby had or was about to be appointed as the Judicial Appointments Commissioner. So he controls as to even whether or not Lord Justice Fulford would sit, would remain as a Lord Judge. And it should be pointed out that by this time he had retired. I mean, he's in his early 50s or mid 50s. So whether he's retired under a cloud is anybody's guess. It certainly means he can progress his private campaigns in support of the gay community, I forget the acronym, but the LBG, whatever it is, and he's online advocating and campaigning for more judges to come out and talking about his sexual life and so forth, while he still, although a retired judge, sits as a judge in various cases. He was in the Constant Martin case recently, as I understand it, and was certainly sitting as a sitting judge, albeit retired, when he refused my application to appeal for leave to appeal the conviction and sentence. And and I knew nothing about Fulford's history, his involvement, both, as we'll come to in due course, his connections to a paedophile called since convicted paedophile called Tomo Carroll, with whom Judge Fulford had close connections in the 70s when they were both sitting in some sort of campaign group again concerning gay rights. But I'll come on to that in more detail. But I didn't know anything about these issues. I did obviously at the time I was initially contacting Alex Beldam, the registrar. I was asking about the independence of any judge that would be appointed, and I got a complete stonewall. I sent 3 separate letters, none of which were responded to or answered or addressed. I simply found out who the judge was from the decision to refuse me leave to appeal, and the cock and bull that the lunacy, as we shall come to when we look at what's called a Form SJ, which is the formal written decisions as to why the judge says you can refuse appeal. And as I mentioned, you can go back, or I didn't properly clarify, you can go back to the court even if the judge refuses on paper, but that's when you risk getting more time if it's refused at the full court stage. So I got this stonewall, and of course it has now come to light, as we shall see, that Fulford had all these revolting connections to paedophiles. He dramatically reduced the sentence of a convicted paedophile who had downloaded images of the most extreme form of child abuse, the torture of children, and he reduced the sentence in that case, which he was sitting on, even after he'd had to apologise for his connections to the paedophile Tomo Carroll. But let's deal with the decision of Judge Fulford in simple terms by just looking at the SJ form, which is only 4 pages long. He states in point 1, introduction, in ordinary circumstances this would have been a straightforward case, as the recorder, in this case Recorder Sellers, set out in his ruling of the 1st of November 2022, the Crown's essentially straightforward allegation was as follows. Mr. Gray is alleged to have entered the court precincts intent on filming court users and, on the Crown's case, instigates a confrontation with Mr. Ford, a court security guard of Afro-Caribbean heritage. He is said to exhibit threatening and abusive words and behaviour to Mr. Ford and eventually to descend into racist comments. Mr. Ford calls for the presence of police and officers from the major crime team who were attending a trial of some gravity came to the foyer to assist. D.S. Bale concludes that he should arrest Mr. Gray for breach of the peace, and Mr. Gray then moves to the exterior. Once there, he punches and spits at D.S. Bale and at his colleague's D.I. Doxy. Mr. Gray is then further arrested for assault and is taken into custody. Once at Patchway, he spits through the wicket gate, 4 officers who have to deal with him over the coming hours. Well, that's the allegation that is completely in itself fabricated. It was clear from the footage, that footage that was made available, and leaving aside the perverting justice issue surrounding the disappeared CCTV, but the video proves that I'm trying to engage not with any court users, but with Mr. Groves, who is a court security staff, in relation to a matter involving Peter Ed and another case involving coincidentally, another barrister from 2 KBW Chambers, as in the case of Recorder Sellers. But the essence of a case is not simply the most serious parts of the criminal allegations from one party. It also has to include, especially where it's self-defense that being pleaded, the grounds of self-defense and the nature of the case as a whole. What Judge Fulford is saying, it should be simple, because the fact that Mr. Gray might have a defence, or the fact that almost every word of the prosecution case is predicated on utter fabrication, as well as perverting justice by disappearing chunks of evidence, is nothing but a complete fiction, because it's not the case. It's nothing to do with what the case was about, other than Fulford's desire to deprive me of any rights as any form of human being, let alone as a defendant, in terms of being able to argue the case, and even leaving aside the fact that the whole trial was illegal because I was denied legal representation because of conflict of interest from the judge all the way down to the individual court staff and police officers. That's all you really need to know about Fulford's attitude to my grounds of defence, because obviously my grounds of appeal, because my grounds of appeal are identical to my grounds of offence. Grounds of self-defence and grounds of defence. That obviously is what the judges should be looking at. There's whole reams of information or rulings in the Archbold that I keep referring to that sets out self-defense and what directions a judge needs to give where self-defense is pleaded, and the onus being on the prosecution to prove that the other side wasn't acting in self-defense, and if they were, that it was not reasonable force. Of no interest to Judge Fulford at all. He's simply rubber stamping anything the CPS want him to rubber stamp. We'll go on to what he then goes on to say. The applicant, this is myself, in his defence, challenged the legality of the initial arrest, maintaining that his behaviour did not justify the step, and he denied that he had made any racist remarks. It's presumably his case. I mean, even the literature, even the amount of spelling mistakes indicates that it hasn't even bothered. Nobody's even bothered to read it at least once to make it verbally comprehensive and grammatical. Given this man is deciding whether or not I stay in prison, or I'm in prison initially on completely trumped up illegal trial proceedings. But anyway. His case was that he had his is my own, was that he had been effectively kidnapped by those arresting him. No, not effectively kidnapped. There is a difference, and it's kidnapped in my defence. So again, fabrication from Judge Fulford. By those arresting him, thereby justifying the punch to and the spit directed at DS Bale, followed by further spitting at other officers because on his case he was acting in lawful self-defence. He maintained he was sexually assaulted, having been detained by the police. It was, however, so now he has to accept that, in fact, there were grounds of other issues in the case other than the summing up that Judge Fulford says should be straightforward, because he then has to say actually it was a bit more complicated, because actually Mr. Gray did have a defence, and he did rely on various issues such as being kidnapped and sexually assaulted. Which doesn't come into which of course Fulford is relying in that summing up at the beginning. He's relying on Recorder Sellers' summing up, so he's parroting the fabrication and whitewash which he's supposed to be holding Sellers to account as the appeal judge, as the independent appeal judge. He goes on to say at point 3, it was, however, the applicant's case at trial that this incident was not an isolated event. He contended that his kidnapping on this occasion formed part of a wider history, as he explained in detail in his 414-paragraph third defence statement, in which he rehearsed the extent of mistreatment he suggests he has experienced over the years at the hands of members of the judiciary. Well, not suggest, because I've got 5 decisions that I've been repeatedly falsely imprisoned and assaulted by the police, who are supposed to be protecting me as a member of the public, not repeatedly assaulting and falsely imprisoning me. And it's not me maintaining it, it's simply the facts of the case. The legal profession, police officers and others involved in the administration of justice. In short, the applicant maintains the present extended altercation simply form part of the many events in which he, as the innocent party, has been mistreated as a consequence of wide-ranging conspiracy against him, which he has committed by exposing. Given that, go on to point 4, given that contention by the applicant, the recorder correctly recognised that a part of this history was relevant and admissible, it being, as just summarised, the applicant's case, that what occurred, including particularly his actions during the incident, were to be explained by his historical context. The applicant was accordingly allowed to explore whether the prosecution witnesses were part of this wider conspiracy. Well, no, I didn't explore that at all. I asked briefly whether the officers knew of me. It seemed unlikely that they wouldn't, given the amount of officers I've had dealings with, which is into the several thousands by now, quite literally, no exaggeration. And I've got these orders from the highest courts in the land saying I'm not allowed to litigate the police and so forth. But it never formed part of the thrust of my case that these officers knew me or were part of any wider conspiracy. Although they were obviously taking their life in their hands if they're going to start arresting people for not being calm, which was the actual formal grounds given, and then touching them up, effectively touching them up seconds later. But anyway, it's another lie from Fulford, and we've hardly even, we're not even at page 2, really. The applicant was accordingly allowed to. So, furthermore, since the defence of self-defence has a subjective element, the recorder accepted that the previous events may have informed his actions. The recorder permitted, therefore, some significant questioning on this history by the applicant, including as to any knowledge on the part of the prosecution witnesses of the previous events and those allegedly involved in them. And the applicant was allowed to develop these matters during his testimony. Inevitably, the recorder, of course, Judge Fulford, well, it's the registrar, Alex Beldam, didn't order any of the transcripts of what evidence I gave under oath or any other part of the proceedings. So how Judge Fulford could know what the judge permitted me to do under oath when it was my allegation that he refused to allow me to properly explore, apart from anything else, no documentation such as the orders that I've been falsely imprisoned. The jury weren't even allowed to know, as I've mentioned before, how many times I've been falsely imprisoned and assaulted, simply that there had been occasions which are simply which I wasn't able to expand upon at all. In fact, when I tried to do that, Judge Sellers started shouting at me and interrogating me himself as to its relevance and obviously dismissing it in the eyes of the jury. That's the truth of it, but of course Fulford will just lie and lie and lie. He's a Lord Justice. He can lie his head off at public expense, and however much he's undermining the rights of the public at large is irrelevant. He's just simply the final nail in the coffin that has been for all the other nails that have been hammered in from Blair, from Judge Blair to Judge Lawrie to now Judge Sellers. So anyway. Inevitably, the recorder had to ensure that only such background matters as were relevant to the issues in the present trial, as just explained, were introduced and explored. Some of the applicant's complaints are focused on instances when the recorder sought on occasion to limit the ambit of the material that the applicant was to be permitted to rely on. It is clear that the recorder took this step when the matters relied on by the applicant were insufficiently linked to the subject matter of the present trial. No examples are given as to what evidence I was trying to bring in, why the judge or recorder Sellers kiboshed it, how much I was allowed to explore incidents. The third defence statement that Judge Fulford refers to, that I relied on and gave evidence, goes into every single allegation with detail and backed up with evidence, just as I backed up evidence in these documentaries. And none of it was allowed into, as I've already said, Judge Lawrie, without a hearing, so illegally anyway. Even the procedure by which bad character is supposed to be submitted and then responded to by the CPS was illegal. And so by the time we're dealing with what Fulford's dealing here, which was the final stages of what I am and not allowed to rely on, it ignores the fact that even to get to this stage, that Judge Lawrie has already trampled on all the basic rights about giving the decision about bad character in a formal judgment, the expectation or the requirement under the rules for the CPS to respond and say why they don't allow this particular evidence or that particular evidence. And of course, all we get from Fulford is a complete whitewash anyway of what might or might not have been allowed in the courtroom. He's acting as though he's actually God, as though he knows exactly what's happened at every stage in the proceedings without transcripts. And the rules, again, that Alex Beldam, the registrar, was supposed to comply with, which was to get relevant where there is dispute about what has happened in the lower court, then it is required for the registrar to get transcripts so that the judge knows exactly what was said between different parties. And Fulford, as a Lord Justice in the criminal court, would be well aware of the requirement that the transcripts that need to be relied on. But he's acting as if he is the CPS. He is the quintessence of the corrupt CPS official that I'm complaining about as part of my grounds of appeal. He goes on to state at point 5. The various documents comprising the grounds of appeal, running to over 150 paragraphs, as with the defence statement, rehearse at some considerable length the matters that, in the applicant's view, explain the full history of this case, and in particular the wide-ranging conspiracy against him. That's the third or fourth time he's mentioned the wide-ranging conspiracy and the conspiracy generally, but not a shred of evidence that I've relied on, and the 150 pages that he talks about is referred to, as we shall see. I mean, he does refer to some of the allegations, but and a little bit of the evidence, but not the evidence that I relied on to support either historically, in particular historically, but even in the current events of November, December 21. I have sought to identify from within this lengthy material any potentially arguable grounds of appeal, to which I now turn. The grounds of appeal. 1. The kidnap defence. 6. The applicant maintains that he was not permitted to advance, certainly sufficiently, this central element of his defence, namely that he had been kidnapped as part of a long-standing conspiracy against him. The contention is unsustainable. The summing up clearly sets out the applicant's case in this regard, and he has failed to identify arguable grounds that he was prevented from introducing material evidence or arguments in this regard relevant to the present case. The judge clearly and extensively summarised the evidence that he had been given on these issues. The jury would have understood the precise nature of the applicant's defence, which the judge allowed him to introduce to the full extent that the material was potentially relevant to the present trial, and he summarised the defence and the facts underpinning it in his summation to the jury. The judge adopted a markedly flexible, indeed generous approach to the extent of the material the applicant was permitted to introduce in this regard. See paragraph 21 of the ruling, the 25th of the October 2022 legal rulings as at 25 of October 2022. Well, I'm not going to bore you with the handwritten appeals, appeal grounds, which I had to submit twice. So I had to write them all out twice while I was in custody, because the first grounds of appeal got lost in the post, in quotation marks, i.e. the Portland prison staff refused to send it recorded and sent it second class, and then it vanished. So obviously delaying the time in which my appeal was considered on the paper, potentially falsely imprisoning me as a consequence of that. But let's not go off on a tangent at this stage. This is completely, utterly fabricated. The complaint was not that I was not allowed to advance my defence of kidnap to the jury. My complaint was that the prosecution was completely illegal because I was glaringly illegally detained by the police in the first place, that Officer Bale did not provide a shred of evidence to justify the claim that I had committed a breach of the peace and therefore threatened violence or committed violence under the ruling of Laporte. And without that evidence, the arrest of myself was illegal, as was the Section 32 searching of myself, the molestation, as it clearly was, that I complained about, which were hand in glove with the kidnapping defence, kidnapping allegation. Those matters, as already been seen, were considered by Recorder Sellers. He had no choice, because I said I wanted to make an application of no case to answer under the Galbraith ruling, which I'm entitled to do at the halfway stage. Every defendant is. And my complaint was that Recorder Sellers was in cahoots with the kidnapping. He had colluded in the kidnapping by lying. You can see on his decision about refusing to allow my no case to answer, because he makes no mention of the specific ruling of Laporte. He just says about violence. He doesn't say whether I committed violence. He then fabricates the assertion that I was arrested to prevent a breach of the peace, when it was in the witness statement and informed, and I can be the recording can hear Bale arresting me for a breach of the peace, not to prevent one. And there is a whole 1,000-mile difference between the two grounds of arrest, that on which whether somebody is being legally detained or not, and effectively kidnapped in my case, has occurred. So, and the point about the no case to answer, and indeed I did at some point try to pursue an abusive process, because I was claiming that I was justifiably complaining that the whole procedure was criminal and criminally corrupt, because it was relying on the fact that I've been kidnapped and sexually assaulted to build a case of my reacting to the CPS colluding in the torture and sexual assault. But because of the nightmare of trying to get any progress with Recorder Lawrie, he was shouting at me when I was trying to make submissions on recorded, over the video link, and just simply stonewall me, gave me like 5 or 10 minutes in all the hearings prior to the trial. I don't actually know what happened to the abusive process or how that was resolved, but certainly with the no case to answer, which obviously overlap with abusive process, because abusive process is any evidence that the CPS is so undermining, or one of the main grounds of abusive process is that the prosecution is so palpably predicated on corruption and villainy from the CPS, undermining the rule of law, especially if the undermining of the rule of law is more serious than the actual charges, because sometimes the abusive process can be overlooked if you're trying to get a terrorist locked up. So if somebody's being a bit naughty in terms of a little bit of perjury here and there, this is the ruling of R.V. Maxwell, if anybody's interested. So obviously the no case to answer overlap with abusive process anyway, but if my complaint is in my appeal that the no case to answer should have prevented the trial from going before a jury, then that's what the judge has to decide. He has to look, he or she or the panel of judges has to look at whether the case should have gone, whether the rationale for the no case to answer was justified, and therefore it's irrelevant what the jury would have done or what went before the jury, because it should never have gone before a jury, because the judge should have thrown it out at the halfway stage on the R.V. Galbraith application. So, in order to address the fact that in order to whitewash and overcome the fact that I was kidnapped, or that I have evidence that I was kidnapped and sexually assaulted, Judge Fulford simply fabricates what my grounds of appeal actually were in the first place, by claiming that I wasn't allowed to advance it in front of a jury, which is nonsensical. If anybody's claiming that they were actually physically being kidnapped and sexually assaulted by the police, their objection would not be that he wasn't allowed to properly canvass it in front of a jury. His objection would be this trial is straight out of Saddam Hussein in the mid-1970s. This trial is a complete and utter collusion in the very offences that the courts are set up to bring people to account for committing. So that's all that needs to be said about this lie. And all Fulford is doing is he's simply joining ranks with the kidnappers, Recorder Sellers or Judge Sellers as he now is, and Judge Lawrie and Judge Blair, and just simply, rather than independently looking at the independent evidence that I was being kidnapped, matter should not have been going to trial. It should have been Bale and Doxey and Ford who should have been facing prosecution. Then obviously it's not going to be an issue about what the jury heard when the victim of the kidnap is finally allowed to give evidence and progress the matter to the trial anyway. And of course, the main grounds that I was being kidnapped and sexually assaulted is predicated on the contents of the footage. And Judge Fulford neglects to mention that there's no mention of the content of the footage and what actually can be seen to have occurred in the footage. In exactly the same way that in Recorder Sellers summing up, in exactly the same way that the no case to answer ruling that I read out in the documentary just ignores the actual hard evidence of the footage and relies on allegations which then Recorder Sellers has to fabricate anyway by inventing, apart from anything else, or one of the many examples, by inventing the assertion that Bale had arrested me to prevent a breach of the peace, which is the only way he can obtain some credible argument that I wasn't being kidnapped on the day. So Judge Fulford goes on to state, the prosecution's opening speech, headline, paragraph 7, it suggested the convictions are unsafe because Crown Counsel, in opening the case, used a shorthand description of the applicant's defence, namely that the relevant police officers had been acting unlawfully. She is criticised for not going further to include his allegations that he'd been kidnapped and sexually assaulted. The convictions are not unsafe for these reasons. The applicant declined the recorder's offer to make an opening speech to the jury when he could have explained how he disputed these allegations. His defence, as revealed in the third defence statement, was extremely lengthy and difficult to follow, and it would have been unwise for the prosecution to attempt to summarise its constituent elements. And in any event, by the time the applicant had cross-examined the prosecution witnesses, had given evidence and had made a closing speech, and the judge had completed the summing up, there would have been clarity. The jury would have had no doubt as to how the applicant was presenting his defence. Well, I didn't need to. The third defence statement dealt obviously mainly with the material of my historical allegations, but the defence statement will, if it's about the incident on the day or an incident in contention, will obviously go into various versions, which I didn't need to do primarily because the ruling of the court was straightforward, that a child could understand violence or threaten violence. Well, you don't have to be a legal genius to or get legal advice from a top silk to see that that's if you haven't committed violence or threatened violence, then you're not committing a breach of the peace. My defence wasn't there was no dispute that I clearly was claiming. I mentioned earlier, haven't I, how Judge Lawrie, without any input from the CPS at all, so Judge Lawrie effectively acting as the CPS, told me that I wasn't being kidnapped when I had an earlier hearing. So he'd already decided that I wasn't being kidnapped, but apart from anything else, he knew that my allegation was that I had been kidnapped, and I'd relied on Laporte and RV Howell to support that, within Mr. Bale's own grounds of arrest. So the fact that Miss Constable had gone before the jury in the opening speech and said that Mr. Gray doesn't have self-defence argument, he claims that the relevant police officers had been acting unlawfully. Acting unlawfully is when you potentially park your car on a curb or something. It's not kidnapping somebody. That's not there's a world of difference. Miss Constable is lying. And then Judge Fulford says, well, I was given a chance to give, in my opening speech, to give my version of events. Absolute rubbish. The one point of law the Recorder Sellers had correct was the authority that stated if somebody isn't calling their own witness, if a defendant isn't calling their own witness, is the only witness in the case and isn't calling another witness, then he's forbidden from giving an opening speech. So, I wanted to give an opening speech. The transcripts would have borne this out, but never mind what the transcripts would have shown, that I wanted to give an opening speech, and Judge Recorder rightly in that one particular case said I wasn't allowed to because I wasn't calling witnesses. Of course, I wasn't calling witnesses because I'd been refused to call witnesses, including the senior investigating officer, Tayyip Hussain, including P.S. Harris, who refused me representation prior to interviewing me. So I wasn't permitted to call a witness, therefore I wasn't calling witnesses, and therefore I wasn't permitted to give an opening speech according to the authority. So the Judge Fulford apparently doesn't even know of the authority, that even though he's a Crown Court, he's a criminal senior judge. But in any event, the fact that the claim that I'd refused to give an opening speech is as big a lie as Miss Constable claiming that my defence was that police officers were acting unlawfully rather than kidnapping and sexually assaulting me. Bearing in mind that Miss Constable is as stated, the onus is on to disprove and to say that I don't have to prove, as I've mentioned, that I was being kidnapped and sexually assaulted, merely that I had reasonable grounds to suspect that I was, or to believe that I was at the time. And so clearly Miss Constable doesn't want to make that clear that was what I'm claiming in the opening speech, so that she lessens, when she's giving an opening speech in front of the jury, so she lessens the amount of evidence or the seriousness of my self-defense act that she has to then rebut. But the lie from Miss Constable is dealt with by another lie from Judge Fulford, that I wasn't given the opportunity to, that I refused the opportunity to give an opening speech to give my side of things. Judge Fulford goes on. The applicant had been sexually assaulted by the officers during his arrest and detention and had lied about these events. Of course, I mean, even the wording of that is a muddle, because he's saying that the applicant had been sexually assaulted by the officers during his arrest and detention and had lied about these events. I mean, who's lying is not made clear. He's presumably referring to the police, but grammatically he's saying that the applicant had lied. That's the implication. But anyway, he goes on to state, this does not constitute grounds of appeal. The assertions relied on in this context were the focus of intensely disputed factual issues in the trial, which were extensively canvassed during the evidence, the applicant's submissions, and the summing up. It was for the jury to decide whether they could be sure of the testimony of the prosecution witnesses. Well, it wasn't extensively canvassed because we can see from Recorder Sellers' decision surrounding the no case to answer application. He simply lies. He lies about the fact that I was arrested to prevent a breach of the peace in the teeth of Bales can be heard on the recording, and states in his witness statement that he arrested me for a breach of the peace. So it is only extensively canvassed to the extent that Judge, as he now is, Judge Sellers lied in his teeth colluded with the lie about why I was being arrested in the first place. In terms of the Section 32 grounds, even if it was extensively canvassed, an appeal can be overturned on the basis that a jury had made a perverse decision. That frequently can be seen in the headlines that the full court can quash an appeal because, and there's grounds of appeal and precedent of aplenty where juries have been misdirected, which obviously they had because Recorder Sellers, apart from anything else, told the jury that I was arrested to prevent a breach of the peace, when he knew full well that I was arrested because Bale was claiming at the time I was for a breach of the peace. Disputes are facts. They're not. You can't have a fact such as what the recording is showing, or the fact that the Section 32 legislation and the Laporte ruling make it clear that if there's some evidence that I was a danger to myself or others moments before, in full view, indeed it was Mr. Doxey I was mainly engaged with before Bale came along. How on earth could Doxey have wanted me to leave 2 minutes before I'm being searched on the basis that I presented as reasonable grounds that I'm a danger to myself or a serious risk of harm to others, or danger to myself or others? It's utter madness. And in any event, it's even if they had been extensively canvassed in terms of the facts. Of course, as I've already pointed out, the recordings aren't mentioned. The contents of the recordings are not mentioned at all in the summing up, as they weren't mentioned in the no case to answer. But even if that itself was an arguable case, that it is not grounds of appeal because something has been extensively canvassed. It is grounds of appeal if it's clear on the evidence, the initial actual evidence, that the jury were misdirected, intimidated, or just simply, not very bright and had got it wrong. And that is a grounds of overturning and quashing an appeal. So lie upon lie upon lie upon lie from Judge Fulford. We go on. The prosecuting authorities failed properly to investigate the applicant's counter-allegations of violence and assault. These matters were fully investigated during the trial, and there is no substance in the suggestion that the further steps should have been taken by the police or the CPS to ensure the applicant's defence was properly presented to a jury. Nothing of relevance to the trial, as opposed to extreme, fanciful and wholly unsubstantiated allegations, has been identified by the applicant as to the investigations he suggests should have been conducted, but which the prosecuting authorities failed to undertake. See also X 13 below in this context. So, ladies and gentlemen, that quintessentializes everything you need to know about the wider conspiracy, the character of Judge Fulford, one of the most senior judges in the land, who deals in all kinds of human rights issues as well as including sexual offence issues. I've said that I have film footage of myself being molested, sexually assaulted, where Bartle prods his finger nearly into my anus when he's searching around my genitals. when Bale is frisking me in the most disgusting and stroking me as though he's stroking his pet cat, and a reference to the Section 32 necessity to have reasonable grounds to believe that somebody is a serious harm, and the ruling of Laporte, and there being absolutely not a shred of anything coming within a million miles of my threatening violence or being violent. Judge Fulford says that I'm being fanciful and says that I haven't provided any evidence, which of course is a lie because I've relied on the film footage as evidence, but he doesn't look at the evidence. He's given no indication that he's even aware that CCTV or body-worn footage even exists. He says at the opening part of his Form SJ that he's made the decision on the paper. So he's accusing me of perjuring myself under oath, perjuring myself in the testimony to the appeal court, claiming that I have film footage showing that I'm being sexually assaulted, showing that I'm being kidnapped under the law. No reference to the rule, Section 32 pace, no mention of the Laporte ruling anywhere in his decision, and no suggestion that he's looked at the footage before accusing me of being fanciful and making stuff up. So he's accusing me of industrial scale perjury whilst not bothering to actually look at the evidence. We then come on to the issue of the trial venue that I've referred to, and Judge Lawrie's decision, his flip-flop from saying it was going to go to London to saying, in fact, it's staying in Gloucester. The case was properly moved from Bristol to another Crown Court at Gloucester, 30 miles away, given the location of the incident in question. There is no substance to the suggestion that jurors at that latter court centre may credibly have been prejudiced against the applicant. There is no evidence that Recorder Sellers was anything but a wholly fair and impartial judge. No support has been provided for the suggestion that the presence of OLS at the trial prejudiced the applicant. There has been no substantial material provided by the applicant to support the various allegations of apparent or actual bias or prejudice. Furthermore, the allegations that OLS may have intimidated or bribed the jury at Gloucester are entirely without foundation. I didn't make any allegation of bribery. I simply said it was that intimidation and bribery was open to occur because of the proximity between the witnesses, the complainants, the judges who are also being accused in part by my grounds of appeal, and the jury. He refers to the OLS. It was the Office Cleaning Services. He doesn't even use the correct title of the firm that I was complaining Mr. Ford was the manager of, and where they also worked as the security and chaperoned the jury at Gloucester. He can't even be bothered to call the organisation with the correct title, and of course he makes no mention of the fact that if he'd used the correct title of Office Cleaning Services, of the fact that Mr. Ford is a manager in that company, and the company, the security staff in that company are chaperoning the jury and giving account of it. Of course, he makes no mention of the fact that Blair has had himself a conflict of interest, as he himself admitted, by his association with Ford, another association there with Ford, and yet refused to recuse himself and chose the venue of down the road, and so forth. So none of the actual reasons that I said it was proposed. He then lies to say that I'd actually said bribery had occurred or intimidation had occurred, which I was simply talking about that being a potential or being much more likely to occur if you've got such close proximity between the jury and the security who are manning them, and Mr. Ford, who is the senior manager of the staff who are controlling the jury. We go on. The location of the trial at Gloucester caused the applicant to suffer torture, contrary to Article 3 ECHR. He's talking about it's actually a Human Rights Act now, so he's not even aware that the European Convention on Human Rights is now statute, has been since the 90s. And he doesn't actually refer to statute, but let's let that go. And the first bit of that paragraph is I'm not going to deal with that about my being caused mental torture, because I had to leave the door open to discuss issues which I may be in breach of a restraining order if I discuss. And it's a very tiny point in comparison with the other ones in some respects. But then he goes on, he conflates the two issues, which are entirely separate anyway, but he then talks about my lack of legal representation, and we'll see what he says about that. Inquiries were made of court centres in London, Isleworth, Inner London, and Southwark, as well as Birmingham, as to whether they could take the case, but in part because of the consequences of COVID-19 pandemic, this was not possible. See the letter of CACD, 6th of December 2022. As to representation, the evidence strongly tends to indicate that the applicant chose not to instruct lawyers to act for him. See summing up, page 133D, and Recorder Sellers' ruling of 1st of November 2022 at paragraph 4. Apart from the applicant's extensive assertions, there is no evidence to support the contention that the entirety of the legal profession in the West of England with relevant experience refused to act for the applicant. Indeed, once the jury had retired and asked a question about the applicant being unrepresented, he seemingly secured the agreement of counsel to represent him at short notice and without apparent difficulty. See summing up of 131F. I emphasise particularly that the applicant refused an offer by the recorder at the outset of the trial in order to secure representation. Well, that last bit is actually true, and I'll deal with the rest of it in a moment. But yes, on the first day of trial, I think it was, or it might have been at a hearing just before the trial, a week or two before, by video link. But in any event, yes, Recorder Sellers, he said, I will adjourn it for you to try and find legal representation. Well, I've already given you the evidence in respect to whether I could find legal representation, because I provided only a couple of years before a High Court judge, with the CPS's agreement, had already agreed that I could not find representation anywhere on the Western Circuit. And I've already provided the correspondence in conjunction with that issue, with Richard Graham's letter pointing out that no barrister would travel to Cardiff, which is equidistant really to Gloucester, from southeast England, and of course, if I you've got to put yourself in my position. If I'm not going to get represented anywhere in the Western Circuit, is it really likely that I'm going to start ringing up lawyers in London and saying I need representation because no lawyer anywhere in the Western Circuit, and as it turns out, South Wales, is prepared to represent me? The first question they're going to answer is why. The second thing they're going to say is this guy's a troublemaker. Clearly, they're not going to immediately assume that their brother and sister solicitors, with or without judicial involvement, are in cahoots and doing me a wrong. Even if that's what they genuinely believe, they're not going to start shouting that from the rooftops. And of course, I'd been effectively punished. I had been on a tag, which I've had this device by orders of Judge Lawrie attached to my leg for a year, which meant I couldn't go anywhere. I couldn't travel anywhere. I had to be at home. I can't remember the exact details of the circumstances now. I've tried to put it out of my mind, but my freedom was I had to be at home after nightfall. So if it was in the summer, I was allowed out a bit longer. But the conditions of the curfew of the tag were draconian. I was deprived of my liberty. It never even counted against sentence when I was eventually sentenced by Judge Lawrie, in teeth of the authority that seems to indicate that I should have been. But in any event, I don't want this case has already been hanging over me for a year. I've been deprived of my liberty for a year. I've already done an equivalent of a month sentence on remand, all of which I made clear in my appeal grounds, but none of which is of any interest to Fulford, who simply fabricates the assertion that gives the impression that it was my fault for refusing to try and find representation that I would never have obtained, as I've made clear, ignoring the ruling of Judge Dingemans, ignoring the letter, all of which was provided to Recorder Sellers, backpedaling a bit in terms of this paragraph. Of course, the issue about COVID or anything else is nonsense. Cases would be transferred all the time. It may mean that there was a longer period to wait before the trial, as all occurred in all cases. In terms of it would have extended the amount of time if the case had been transferred to London. But Birmingham was out of the picture because the whole point of London was that I could afford to go to London. I couldn't afford to go to Birmingham sort of on a regular basis. Judge Fulford, it doesn't. He talks about Article 3 in terms of torture, but he doesn't mention Article 6 of my right to a fair hearing before a fair and independent tribunal. So, returning to the paragraph 11 of Fulford's findings in respect to legal representation, just to recap on this, because there's two stories that's relevant to disproving this assertion and indeed proving the extent to which I am being persecuted and terrorized by both the police and with the cahoots of corrupt members of the legal establishment in Bristol. When he states here, apart from the applicant's extensive assertions, there is no evidence to support the contention that the entirety of the legal profession of the West of England with relevant experience refused to act for the applicant. Indeed, once the jury had retired and asked a question about the applicant being unrepresented, he seemingly secured the agreement of counsel to represent him at short notice and without apparent difficulty. See summing up at 131F. In any event, we've already seen, haven't we? First of all, there's the letter from Richard Graham, clearly establishing that he can't even get representation from barristers or his associates who do this sort of thing anywhere in the Eastern Circuit. And I'd had to go to Richard Graham because no one would represent me on the Western Circuit. And the evidence I had to prove that was obviously apart from anything else, the judgment of His Lordship Lord Stuart Smith, where he's gone into very great detail about the fact that it was agreed with the CPS at a hearing in 2018 and with Lord Justice Dingeman, as he now is, that I could not find representation anywhere on the Western Circuit, and ergo the order to direct the case to the Eastern Circuit, which was London. And all that material was put on file and sent to Gloucester Crown Court, which of course, because I never got a hearing in front of Judge Lawrie at all in respect to transfer or legal representations, apart from just being able to mention the fact that Judge Lawrie had overturned the decision to transfer the case to London. But all that evidence was on file and therefore in the bundles before Judge Fulford. So absolute fabrication, that I didn't provide evidence that I couldn't get representation on the Western Circuit. But of course, he says the same thing about the sexual assault allegations, and the judge doesn't even bother to look at the footage in respect to those allegations. So we know what his position is, just to lie about anything that will somehow make these criminal proceedings credible. And there's two further issues surrounding Mr. Young. As it turned out, I didn't know who Mr. Young was. He's a solicitor advocate, apparently, the same sort of role that Richard Graham does, which is someone who's midway between a solicitor and a barrister, and doesn't actually have the full qualifications of a barrister. Let alone a silk. So, of course, even if I had been able to be represented by Mr. Young, I'm being deprived of a barrister who's obviously better qualified to represent, and I'm having to be represented by a solicitor advocate. Obviously, that would be better than nothing. I accept that, especially in my circumstances. And I was obviously pleased for Mr. Young to agree to represent me. I met him out in the hallway, and I had asked several barristers. All of them had refused. Once it became clear that I was going to be convicted in the glaring stitch-up in the courtroom in question before Recorder Sellers. So, but when I spoke to Mr. Young, he said he was prepared to represent me, but he would need to sort out legal aid issues and ask for an adjournment, which in any event Robin Sellers refused. So, part of my grounds of appeal was breach of my Article 6 right to legal representation, because the judge ignores the fact that Robin Sellers refused to allow me to be represented, refused the adjournment that was requested by Mr. Young, and ploughed on with sentencing that day. For no apparent reason. There was no urgency. I've been on bail for a year. There was no particular objection there's no reason why he couldn't simply have adjourned for another couple of weeks while I gave instructions to Mr. Young and he got legal aid. But as it turned out, Mr. Young had a conflict of interest. He is partnered up with a solicitor who I've mentioned in passing, Mr. Alan Hall, and the firm itself is called Allen's Young, so they are in the same organisation, the same firm. And I'd received £600 compensation because not Mr. Hall himself, but about a solicitor working for him, I forget his name, Damien someone rather, had failed to attend meetings, had not acted as he should be doing as a solicitor, and he was ordered by the Law Society to pay £600 compensation for providing poor service to his client. So clearly, if I'd known that at the time, Mr. Young didn't properly introduce himself. He didn't say what organisation he worked for. He claimed in a letter that he sent me whilst I was in custody after having been sentenced, 17th of March 23, once I found out that Mr. Hall that he was firmed up with Mr. Hall, I obviously inquired into that and wanted him to provide some evidence I could provide the appeal court. Bearing in mind this letter was provided to the appeal court. Let me just check. This was after the decision of Lord Justice Fulford, but obviously I didn't have this information at the time that Fulford had made his decision. But the statement from the key point that Mr. Young was prepared to put in writing to me was the following. I spoke to you after the hearing, and it was established that you could not instruct me because I am a director of Allen's Young Solicitors, who are part of Allen Hall Limited. You informed me that you had had previous dealings with Allen Hall Limited, which had led to you making a complaint against that firm, and you were dissatisfied with their services. Therefore, it became apparent that you would not have been able to instruct me in any event. Well, as I say, it seemed unlikely that given his relationship with Mr. Hall, given my reputation amongst the legal establishment, given that it was a reasonably high-profile case in which involved swarms of police officers attending the hearing at Gloucester, and Mr. Hall, had free time and he was hanging around and obviously came into the courtroom to make representations initially to Mr. Recorder Sellers, which Recorder Sellers refused anyway. That he didn't know who Ben Gray was, that I wasn't the Ben Gray who's been involved in these complaints against his partner Alan Hall, and so forth, and he knew nothing of this situation. And of course, landing me in it because he gave the appearance or gave the excuse for both Recorder Sellers and Judge Fulford to claim that the offer of representation from Mr. Young proved that my claim as fallacious, that I could not get representation, and effectively being branded a liar, certainly by Mr. Sellers. But the whole thing was completely contrived, I suggest. But in any event, I couldn't have been represented by Mr. Young, and it simply proved my point in terms of everybody knowing everybody and the conflict of interest. And the only offer I could get of representation is from somebody who claims not to know me, who claims not to know of my complaint, my successful complaint. He doesn't mention in the brief paragraph there that it was a successful complaint against the Law Society, which seemed to be made a difference in terms of everything. But assuming he didn't know who I was, or it wasn't contrived from the outset, it obviously completely disproved what Judge Fulford had stated. And there's yet a second issue, which is worth bearing in mind and worth detailing as evidence of the most glaring corruption possible, and indeed I relied on it, although I wasn't able to show evidence of this situation, of this event, in the actual proceedings in Gloucester, as proof that I am being conspired against and I'm being persecuted by corrupt elements within the Avon and Somerset Police and the legal establishment. And in a moment, I'm going to show you a video, but before I do that, I'll just give you a couple of details. This involved what I found out to be a Mr. Torian White, who I received letters from, legal letters, and from probation services, I think, on one occasion, and one about to do with car licenses or something, over a period of a couple of years, and with the name Torian White on the letterhead in the house that I own in Bristol. and obviously I've had nobody living with me since I moved here for the past 20 years. So clearly that my address was being used bogusly. I did try to pursue it, but I got short shrift. I think I called the probation services to tell this organisation that there's no Taurian white living here, and I got hung up on. So they weren't concerned that this man who was on probation had been given a false address, my home address, as address where he's living. Then I got a visit from an officer by the name of a name from a PC Radcliffe, in a mask because it was COVID times, and at 1:45. If I didn't open the door and speak to him, he made it clear that he was going to kick the door in. So this is obviously, I'm extremely nervous because I've been falsely imprisoned by the police on numerous occasions. And I assume it's got something to do with some yet further trumped up allegation against me. But it turns out, and I'll shut up now and show you the video, but it turns out that in fact I was sent here, the police were sent to my address on the basis that Taurian White was continuing to give my address as his home address, in the event that he was going to be that he needed to give an address so he wasn't remanded and allowed to be on bail. So let's look at the video, and then I'll come back and discuss it a bit more in terms of the aftermath.
What's the reasonable suspicion of what?
Okay, so I'll just get the paperwork out, shall I? So this is the address given by Tyrone White as his home address.
Tyrone White?
Yeah.
I've complained about him. There's nobody living here called Tyrone White. I've been getting posts from Tyrone White to do with vehicles and stuff, and I've called the police.
Oh, okay.
Okay, my name's Benjamin Gray. I'm well known to the police. I'm involved in all kinds of situations.
Yeah, sure.
So, I've tried to clear this up. I've called the police about half a year ago.
Okay.
So,
do you want to just come in and have a quick chat about it then?
Well, I mean, no, I don't. I mean, are you saying that you have to search it, even though you know that I can identify myself? I can get your passport.
That'd be fantastic.
Yeah.
Thank you very much. Also, Mr. Gray.
Could you not be on the property?
You said that you've had a load of. Sorry, mate. You said that you've had a load of stuff for this, Mr. White. Come to
Yeah.
Have you got any of that here?
No, I haven't kept it, but I've had letters coming through.
Okay, I'm really sorry.
I've had somebody else, a Miss Connolly or Connor, has also given this address, and I've had police knocking round.
Yes, we are, mate. I'll point you back shortly.
Can you get this sorted, please? Because I'm Benjamin Gray. No, there's no other person living here.
We're at 6 Boswell Street, mate. I'm just having a chat with the person who lives here at the moment. I think we've been sold to Joey. We're just going to get some details. We'll do. Right, we'll start again, Mr. Gray, if that's okay. My name's Simon Ratcliffe.
Mm-hmm.
If you don't mind, I'll just take a few details, if that's okay.
Yeah.
And then
I do mind, but I don't have any choice, do I? I mean, you know, if I've tried to get this White investigated. He's that I've been getting failing to show at magistrates' court and God knows what.
Oh, really?
And I've called the police, told them about that, and you know, the fact that I'm known to the police seems a bit odd that they wouldn't know.
Like I said, we've got a gentleman in custody at the moment saying that this was his address, and I do apologise for getting you up at this time.
Well, you haven't got me up, thank God, but I mean, obviously if I'm getting a knock at the door at quarter to 1 o'clock, it's not going to be good news, is it?
No, okay, yeah, I appreciate that. So you said that you've been having a load of paperwork, court summons, you said?
Not a load of paperwork. I probably had about 3 or 4 letters in the last 3 or 4 years. I think there may have been a white who was a witness in the case. Is he a black man or black youth, sort of early 20s? Because there was a kid who was that rings a bell that was involved in the court case in about 2008.
Okay. You said some vehicle paperwork as well?
I mean, I can't remember what it was about.
Sorry,
I mean, the only issue is that you've identified me. I mean, you know, I mean, you know, where do we go from there? If I've identified myself as Benjamin Gray, and you know me anyway, the police know me.
Ben, I've never met you before.
No, please don't call me Ben. Could you call me Mr. Gray?
I can call you Mr. Gray.
Yeah, thank you. Well,
yeah.
just
so
don't just you know,
I've never met
first
you.
name terms isn't really appropriate, is it?
Okay, no problem. Let's start again.
No, we're not starting again. We're starting from the conversation we've been having. Either you are satisfied that I'm Benjamin Gray and that there's no Tyrone White that has ever lived here, all right? Certainly in the 15 years since I've owned the house, okay? I mean, the police own half of this house because I've sued the police and they've won the case and they therefore own 6 Boswell Street. So this guy is telling you that he's living in a house that you in fact part own or your chief constable owns.
Okay.
Okay, so
I probably don't know anything about that.
well, no, I mean the point is, do you now still want to search the place? If you do, please get it over with. If you don't, if you're satisfied that I'm Benjamin Gray, then please go away. Okay.
Okay. Let me just get a supervisor on the phone. Once I've done that.
Yeah. Well, I mean, can I close the door and you can do what you have to do? And
as long as you promise that you're going to open the door to us again.
Well, why would I have opened it in the first place if I'm not going to open it again?
Mr. Gray, I think you've probably had some bad experiences with the police. I'm being really polite with you. Okay, just let me do my job.
No, it's no question of whether you're being polite or not. I don't have to be grateful for your being polite.
No,
am I a suspect? Are you here about me? So
I'm not
okay,
here about
fine,
you.
fine. What I want you to do is
because this address
yeah,
has been
yeah. Please sort it out, though. Please sort it out. Yeah, but that's not no skin on my nose, is it?
Yeah,
it's got nothing to do with me.
Okay, cool.
I mean, the only issue. Well, I mean, whether I close the door or shut it, all I want you to do is to satisfy yourself that I'm me, Benjamin Gray,
I've
and that
seen
you
your
don't.
ID.
Yeah, so
I'm satisfied with that, Benjamin.
But what else do you need for you to go away? Though? What other step do you have to take, or whatever?
I'll get on with the supervisor.
Yeah, please do that.
Lovely.
So there we have this officer who's clearly being, to some degree, hostile. He's going on about my reputation with the police or my relationship with the police and so on and so forth. He did apologise, but he didn't seem particularly concerned that once it was established Tyrone White was giving a bogus bail address. That this had occurred, and I got no further response from the police as to whether which had clearly been criminality from Mr. White, not only because he was giving a false bail address and misleading the police, and the involvement of Alan Hall, which we'll come to in a minute, but obviously there's fear of unlawful violence because these officers were threatening to kick my door in and would have done in order to establish whether Mr. White lived at this address. I'm not entirely sure whether he did indeed have the powers to kick my door in, but he certainly threatened to do that, and it's certainly harassment by any criteria. Meanwhile, or sort of shortly after this event, I should have mentioned the 6th of April 2021, I contacted Alan Hall and said, "What is going on? I'm getting a visit from because of your client is giving my address falsely as his home address." And but before I wrote that letter, I received on the 7th of April, i.e. the following day, so clearly after this gentleman called Ned Kemp, who is a solicitor working for Alan Hall, I got this letter, which I'll put up on your screen, talking about the upshot of Mr. White's arrest. Refused charge, Patchway Police Station, allegation concerned in the supply Class B, 5th of the 4th, 21. I was pleased to help with this matter. Allegation, I refer to your attendance at Patchway Police Station on 6th of April 2021 when you were interviewed in relation to an allegation of being concerned in the supply of cannabis. Police disclosure, the police pulled over a Honda around 2100 hours on the 5th of April 2021, and within the vehicle was green vegetable matter, snap bags, scales, small bag of white powder, and a pot containing vegetable matter. Your instructions, you told me that you were not aware of any drug dealing going on and were not involved. We put forward your prepared statement and there was no interview. Outcome, we are pleased to confirm that the allegation has been refused charge due to insufficient evidence. This means that there will be no further action against you. We remind you that if you're arrested by the police, you should always ask for Alan Hall to attend. We're available 24 blah blah. Well, obviously I haven't given my address on the screen there, but obviously I wouldn't have had this letter from Torian White regarding Torian White and Alan Hall if this wasn't my correct address. There we have. I've told the officer that Mr. White doesn't live at this address. This isn't his home address. This isn't his address that he can use for bail or any other matter. The officer is completely unconcerned. He's given a sort of a passing apology, while expressed hostility in other respects, but he's given a passing apology. But then he's gone back to the police station or contacted the police station that he was making inquiries for, and clearly not informed the police sergeant, whoever was the boss, the officer in charge of this particular investigation. And so Torian White simply carries on using my address as his home address, to the extent that I then get a letter from Alan Hall. And of course, Alan Hall I've complained about, so they will have known my address. They know Ben Gray. And it's almost a certainty that indeed they told Torian White that Mr. Gray is some loner, outsider who doesn't have a very good relationship with the police or the legal establishment here. Use his address. He won't be able to do anything. The judges are as corrupt as the day is long, certainly when it comes to Mr. Gray. And you can, if you've got any issues that you need to use for a bail address or for any other matter, just use Mr. Gray's address, and there'll be no problem. And of course, meanwhile, they can get their revenge for my having successfully complained against them to the Law Society. They can enact their vendetta. And of course, the police are delighted, because it gives them a chance to come and terrorise me and threaten to kick my door in on this bogus bail address issue. So I contacted the Law Society, and not the Law Society, the Solicitors Regulation Authority, and unfortunately I've mislaid the actual response letter from the powers that be. Before I contacted the SRA, I obviously contacted Ned Kemp himself, and his response, dated the 8th of April 2021, Dear Mr. Gray, thank you for your hand-delivered letter dated the 8th of April 2021. I acknowledge safe receipt, and I can confirm that the matter has been dealt with as appropriate. I thank you for bringing it to my attention, and I apologise for any inconvenience caused. So it's not a matter of inconvenience. Of course, there was inconvenience, but it was more the terror, the fear, and the utter corruption that because of Mr. Kemp being in cahoots with Torian White, the suspected criminal, and the corrupt police officers who then come and bang on my door at midnight, threatening to kick it in if I don't answer, and then interrogating me about whether Mr. Torian White lives here, when almost certainly the police would have known that Torian White didn't live here, and certainly Ned Kemp knew that Mr. White didn't live here, and knew that it was Mr. Gray living on his own in Bristol. So I referred the matter to the SRA, the Solicitors Regulation Authority. I said that this solicitor is clearly acting improperly. He's supposed to act honestly at all times. And he must have knowingly allowed the police to use and allowed his client to give a false bail address to have me harassed and terrorised by the police on this bogus address. The matter was looked at. Unfortunately, I've mislaid the response letter from Danielle Paul, who was the investigator for the Solicitors Regulation Authority, but they dismissed my complaint out of hand. The case reference is RGC quadruple 080148. But so it can be clarified that was the attitude taken by the SRA, and they said that any evidence of criminality, which clearly overlapped, was for me and not for them. So if they have evidence that a solicitor has acted criminally, it's up to the person who's contacted the SRA to complain. They will just simply ignore any criminality from the solicitor in question that they're supposed to be regulating for improper conduct, which may of course involve criminality, and it certainly did in Mr. Kemp's case. So that was from this harassment, this terrorism, this corruption surrounding the visit from the police and the bogus bail address was actually referred to and relied on when I gave evidence in the court before Robin Sellers. And then by pure coincidence, and obviously I have a lot of these very unhappy coincidences, the one barrister solicitor who is solicitor advocate who is prepared to represent me is in cahoots with and literally partnered up with the firm that I was complaining about of being terrorized and having the knock on the door at midnight. And of course, the irony of my giving that evidence in terms of proving the extent of corruption and wicked persecution being carried out by the authorities, solicitors and police in the locale, and of course Robin Sellers himself, was that I would have terrorized the jury more into thinking, well, we better find Mr. Gray guilty, otherwise we're going to get our address used as bail addresses by Mr. Kemp and gang. So, but obviously that was not only was evidence of corruption in its own right, and certainly Robin Sellers' own collapse, because I referred him to it, and he suppressed evidence of it, although it was, of course, submitted in pre-trial matters. By any criteria, if that was the choice, if that was my one choice, and of course it wasn't a choice, I wasn't able to select of my own devising which solicitor I should choose to act for me. I had foisted on me by pure coincidence that the one person who was agreeing to represent me. That's not a choice. That's simply having you get this or nothing. And of course, what do I get? I get a solicitor advocate who has accepted he couldn't have represented me anyway if he had known about my complaint about Alan Hall and the conduct of the very company in which he has partnered up with was evidence of the sort of corruption I was canvassing before the court establishment in my trial. And the matter, viewers, doesn't end there. Indeed, in some ways, it's simply the beginning, as this documentary, I hope, establishes. Because after Judge Fulford's dismissal, as I've indicated, and as anybody that takes an interest in these sort of matters would know, so as established, the decision on the paper of Judge Fulford didn't end there. I did have another bite of the cherry in terms of going to the full court, but as I've established, I risked getting an extended sentence, or having effectively an extended sentence, because I would have to relive or renew some of the sentence I'd already served, which the court can inflict on a failed appellant if they renew it to the full appeal. That's supposed to discourage expensive costs and so forth. And of course, the judge had recommended that I did get a further sentence if I renewed. As he would do, because he obviously doesn't want me to canvass the extent of his wicked corruption and collusion before the full court. But of course, a full court, if you're not represented, you don't even get a hear. You're not even able to make submissions. You're not even allowed to attend. You can attend if you're at large, if you've been released from your sentence prior to the hearing, but you cannot get involved in the proceedings. And if you're still in custody, you're not even allowed necessarily to even be present at the hearing. God knows why they why they've made those strictures in. And if you read through the various processes by which appeal submissions are made and documents are, fresh evidence is relied on, it's an extremely complicated matter. You have to use special forms. And a lot of it refers to your advocate. The advocate will do this or that. So if you're not represented by a barrister, especially if you haven't had advice on whether you should should appeal in the first place or should renew your appeal, then of course, God knows what will actually go in front of the full court. But you can see that Judge Fulford is just lying. And of course, they would have got colleagues or close associates or judges as corrupt or even more corrupt, if it was possible, than Judge Fulford to second guess or look at again Judge Fulford's decision. And of course, if my entire premise is that Judge Fulford is colluding in sexual torture and lying in his teeth and so forth, then of course that isn't going to get. Then all I will get is a whitewash of the whitewash of the whitewash, and potentially more prison into the bargain. So I had to withdraw, and of course, But in the meantime, before I finally withdrew my application, I attempted to get legal representation because I was still entitled. The legal aid funding law actually says that the barrister who is present at somebody who's been convicted and sentenced is included in the legal aid payment. The advice as to whether or not that the client should appeal and take it all the way to a full court if necessary. But of course, I didn't have that because I didn't have representation in the first place. Indeed, one of my grounds of appeal was that I was denied representation through all the machinations and lies that I have canvassed surrounding Lawrie, Sellers, and Fulford. So I was on a hiding to nothing in terms of I had no basis upon which I could, although I knew I had been stitched up like a kipper and that I was entitled to legal advice. As I mentioned earlier in the documentary, I was entitled to legal aided advice on whether I should pursue an appeal against conviction and sentence. And of course, I knew that I'd been stitched up like a kipper, so I knew that I had grounds of appeal. So after I was sentenced, I made strenuous efforts to get representation whilst I was in custody. There's various prison newspapers that offer even people that have been convicted and sentenced, if they're not happy with the advice and reasons given by their barrister, they can actually go to another firm to have them give a second opinion about whether the initial advice was correct, and they can be legally funded for that. And I contacted initially somebody called John Daly of a company called Eden Legal Services. So John Dealey, E-E-L-E-Y. John Dealey was a solicitor who I contacted through the prison newspapers, and he was advertising his possibility of representation. And he did initially agree to represent me. And there's the letter dated the 14th of April 2023. Where he states, "Your opposed appeal. Thank you for returning your legal aid forms to me. I can confirm that your case is now funded. The purpose of this letter is to agree and record certain information between you and Legal Services Limited." So far, so good. I've got representation at last. I had to be convicted to get representation, but at least I got it, and my spirits were starting to rise because of the travesty of justice to which I've been subjected. And not just me, of course. I hate to. I'm sure I don't have to point out, but obviously everybody is the victim of injustice if the courts are so corrupt that they can treat anybody in the way they treated me. However, as to be expected, the raised spirits was short-lived, because on the 27th of April, I received a letter from Mr. Dealey with the following. He says, "I have not been able to consider it in detail, i.e. the paperwork surrounding my appeal issues that he had been handed from the Criminal Appeals Court, because obviously I'd made my appeal, Judge Fulford had refused it. So at this stage, this is long after Judge Fulford had refused the appeal on paper, but of course I still need advice about whether I should continue to appeal to the full court, or indeed, even if the full court had refused or I'd rejected it, I'd withdrawn the application, whether I could go to the Criminal Cases Review Commission, which is another option and doesn't involve possibility of further custody. But he says, "I've not been able to consider it in detail as the paperwork runs to over 4,500 pages and I have very limited funding available at the current time. In order to read the papers, I will have to apply to the Legal Aid Agency for a very substantial extension, which they may not grant. I can confirm that you passed the financial test for legal aid, although when you are released, you will have to advise of any changes in your financial position. However, the case has to pass the Sufficient Benefit Test, SBT, which in essence asks the following question. Would a reasonable private paying individual of moderate means pay for such legal advice and assistance? If the answer to this question is no, then the LAA, the Legal Aid Agency, will not extend the funding. The issue the LAA will have to consider carefully is the benefit to you by successfully appealing. This is normally being released from prison, often with a lengthy term still to serve, but you will by then have been released. If an application has no previous convictions, then it can be of great benefit to revert to being a person of good character, but this does not apply to your case as you have a number of previous convictions for similar offences. In other words, the LAA will have to be persuaded to allow a substantial funding extension on the basis that they will have to agree that the case passes the SBT. It would be very helpful, therefore, if you could send me a short, succinct letter stating why this case passes the SBT. I will then send this as an attachment to the application and ask them to grant it. Well, this is all utter nonsense, fabrication on a par with, or perhaps not as serious as Judge Fulford's himself's fabrications, but utter nonsense. He's been funded. I think it's £300 odd, £315, something like that. This is standard issue initial funding for representation on appeal, just for advice. It's not to say that the funding will then be extended, and this is where the SBT test will come in, if there are initial grounds to appeal that is agreed by the firm that then would involve a barrister to advise and take instructions upon. The £315 has already been paid to Mr. Dealey. He asked me to provide a letter to outline why the test is met in terms of the appeal being legally aided. Well, he's got the same documents, the initial documents or the key documents, however many thousands of pages were also included as evidence that wasn't even allowed into court anyway in the lower court. But assuming that at some stage a solicitor would have to read all of it, the only key documents are my grounds of appeal, which were about 50 paragraphs of large handwriting, because my handwriting was very large in order to be legible for the court, because obviously I didn't have access to a computer and so forth. And the decision of Judge Fulford, and the extent to which much of what Fulford's saying can be seen on anybody that knows the slightest iota about criminal proceedings. The key point, obviously, is that Judge Fulford has said you weren't sexually assaulted. The issue about Laporte, well, there's no evidence of violence or threatened violence. The change of testimony in terms of why I'd been arrested, all of that was neatly set out in clear paragraphs. And so John Dealey clearly had a framework where he could say this man has not faced a fair trial. Judge Fulford's decisions are clearly legal nonsense from start to finish by any criteria. How can the judge say that it is fanciful that you have been the victim of sexual assault or kidnap, when there's no reference to the law of what constitutes kidnap or of what a justified arrest under full breach of the peace is, and there's no viewing of any of the footage, and of course there is evidence of missing CCTV footage, which is perverting justice in its own right. So and all of that could have been dealt with in 10 minutes, and obviously there was when I contacted Mr. Dealey, which by phone several occasions, he made it clear he hadn't even received the film footage on which the allegations rely, and clearly, even if he hadn't looked at the footage, he could clearly tell that it was monstrously unjust and clearly collusion for Fulford to state that accuse me of lying and being fanciful about such serious allegations against serving police officers, without actually viewing the evidence upon which it was relied, and indeed the very short no case to answer document judgment from Judge Sellers, or Recorder Sellers as he then was, clearly setting out the absolute nonsense Galbraith test, or the no case to answer, again without any reference to the content of the film footage that Mr. Dealey could have raced through, that we've seen earlier in the first part of Barbarians at the Gate, which he could have viewed in a matter of minutes and set against the law of Laporte and Section 32 of Pace and so forth. So, and the assertion is that even if I've been subjected to the most outrageous illegal trial, I would suggest in British history, I mean, I don't know about the details of the post office cases, but there's no suggestion that the post office workers, although they were stitched up and were falsely imprisoned, which is manifestly an outrage, an egregious outrage, is not that they were not the victims of sexual assault or kidnap prior to being further kidnapped by the 18-month sentence imposed by Sellers and Fulford. So he's making it clear in terms that he could not care less. He's not even indicated that he's actually read any of the documents. So he's trousered the £300 although it was claimed by the Legal Aid Authority, he never claimed it. Although when did he decide not to claim it? Because I made the complaint to the Legal Aid Authority a year after this letter from Mr. Dealey. It's a corrupt nonsense from start to finish from Mr. Dealey, and I've reported him to the SRA recently. And obviously they will almost inevitably rubber stamp his decision and come back with a load of cock and bull as to why he's not acting corruptly, because he's taking legal aid money illegally. He's concocting some reason why he can't do the actual work that he was paid the £315 for, and he's clearly giving me a legal advice about at what stage the benefit test would be relevant. The benefit test would surely only take place once the solicitor has initially said that there are some grounds that I can pursue with the appeal court. I then wrote to another firm who was offering to represent me, and this is Wells Burkham. Indeed, I think it was One Pump Court Chambers who initially advertised for representation for appeal, advice on appeal, and so forth. And they said they couldn't represent me until I got a solicitor to act for me, and they said that they usually work with Wells Burkham. Wells Burkham got me to fill in a whole load of legal aid paperwork, and then claimed that I was not entitled to legal aid because Judge Fulford had made his decision on the paper that there's a box, and it'll come up on the screen in a moment, where it says legal aid, and there's a box to tick as to whether or not the judge will allow it. That legal aid box is relevant only to being legal aid funded if the judge gives you leave to appeal. If the judge gives you leave to appeal, then you will get funding from a barrister, funding to pay for a barrister to go before the full court, where that barrister is able to make representations about the grounds of appeal, or certainly prepare the bundles to put before the full court in terms of that matter. But so the legal aid is not retrospective. It doesn't refer to whether you could get legal aid about advice about whether or not you could appeal in the first place, because that would have cancelled itself out. That would have mean the judge was refusing legal aid when you've already reached the stage that you've got a barrister to represent you, and they've made the application to the first judge, the single judge, who then says you're not allowed to have legal aid, which would have meant that the judge would have never had the documents in front of them in the first place. As I've already said, the legal aid funding to people who are represented, which is most people, includes legal advice about whether you get grounds of appeal. So if the barrister says you do have grounds of appeal, then apply to the Court of Appeal in London for leave to appeal. They've already been provided legal aid funding as a matter of course. If you're impoverished and the client is entitled to legal aid generally, then the legal aid has already been covered at that stage. And then if the judge says that person is entitled to, does have grounds of appeal, have an arguable case, that's all that needs to occur. It doesn't have to be complete cut and dried. Every single case is proved against the illegality of the trial. It just has to be an arguable case, which obviously isn't a particularly high bar. And then if you do have that, the judge will then grant further legal aid for the funding of further representation. But Wells Burkham, Mr. Burkham, Alan Burkham to use his full name, he sent this letter dated the 10th of August 2023. We acknowledge receipt of your letter, your email dated the 9th of August. You wish for us to provide advice and assistance in relation to a renewed application for leave to appeal. We maintain, in light of the single judge's decision to refuse a representation order, that you are not entitled to publicly funded advice and assistance in relation to your appeal. Well, if that was the case, then how did John Dealey get legal aid? He got legal aid funding long after Judge Fulford had made his decision and ticked the box about legal aid funding. And of course, as I've already explained, it can't be retrospective. The judge can't say you refused legal aid funding, because most people on legal aid funding have no money. Therefore, he's effectively ordering the person who's been advised by their barrister to appeal, who's on legal aid and therefore doesn't have any money and is probably in custody and therefore doesn't have any access to money, even if he wanted it, even if he may have a few quid outside. But if they fit the criteria to be legally aid funded in the first place, Alan Burkham is virtually saying that is basically saying they would have to pay that back and that it would be retrospective. It's utter fabrication. And of course, if he was aware, as he was, because I referred him to the letter from John Dealey getting legal aid, then he's effectively accusing John Dealey of fraudulently taking money for legal advice. So there we have it. We're nearly at the concluding stages of Barbarians at the Gate, Part 3. You can see from the conduct and the correspondence from Mr. Dealey and Mr. Burkham that they are simply corrupt adjuncts to the High Court Judge Fulford, who himself is basically he's taken over from Warby, Lord Justice Warby, effectively as the corrupt judge to take care of all matters concerning Ben Gray and rope in any potential chance I have of having independent representation and having my side of events, my side of my understanding of the law, my rights properly enforced according to the statutory will of Parliament. The will of Parliament, the Acts of Parliament mean nothing to either Judge Fulford or these two solicitors, Mr. Dealey and Mr. Burkham, to name but a few. It would have been seen, in terms of Mr. Dealey, just to finish off on, it would have actually been seen on, you only had to look at Lord Justice Fulford's decision about effectively accusing me of lying about the sexual assault, kidnap allegations without having viewed the footage. That in essence sums up all my complaints against all judges connected to all matters that I will be providing more documents, more video evidence surrounding going back to 2005 here in Bristol. And they do exactly the same thing throughout my all my allegations, which is that I'm either being assaulted by police and or civilians. The police, other police officers who are supposed to be investigating other police officers collude in the assaults, as do the CPS, as do judges whenever these matters are put before them, and a complete whitewash as to the contents of the footage on which all the allegations either way turn is applied to every single decision. They treat the case as if any hard evidence such as CCTV and video sound recorded evidence doesn't exist at all. It has no relevance to the evidence they're supposed to be sifting and basing their decisions on. And of course, it is the only material that really matters, because people say all kinds of things, and police officers, as much as civilians, lie their head off, especially to save their own skins and if they want to enforce a prosecution against somebody else. So as I say, that's all that really needs to be said, and I don't need to add further and go into further legal details at this point. I will conclude, however, and it's essential that the character of Lord Justice Fulford is canvassed a little bit in again to support my general allegations of corruption within the judiciary. Now, we returned to earlier in this documentary. I mentioned that the registrar, who is, I think, herself qualifies as a judge, Alex Beldam, was contacted by me several times to ask about the listing process in terms of the selection of a judge that would be independent and able to assess my counter allegations against other judges who I say have colluded in police torture and kidnaps and perjury and perverting justice and that sort of stuff, which is obviously pivotal to my allegations of my defence of self-defence and the issues surrounding what went before the jury and what allegations I'm making generally against the judiciary, with a view to having the judges themselves criminally investigated under the the common law offence of misconduct in judicial or public office. And as I say, Judge Beldam gave no response, and yet, and I've complained obviously already about the lack of independence from Judge Fulford, and him being clearly deliberately listed by Beldam as the least suitable, most connected judge possible, not least because Lord Justice Warby, as now sits on the Judicial Appointments Committee, and I'm accusing Judge Warby of being especially venal, especially crooked, especially tangled up in all the allegations I'm making that I'm being subject to the sort of abuses that I've complained about from the police and the CPS. But further evidence came to light after I was finally released from custody after the 9 months in prison, prior to the second part of my sentence to be served in the community under quite strict probation conditions, which included not being able to publish videos like this, any material about the police or the courts or the members of the judiciary, and not being able to film police if I interact with them on any circumstance. So that was in place for 9 months, and it's only now that I've come to the end of those license conditions that were put in place for no reason that I could understand other than it was to suit the purposes of the corrupt police and judiciary. I'm now free from that, and in any event, I come to the evidence that to Judge Fulford, Adrian Fulford, what was specifically chosen by Beldam because of his corrupt, shady past, and the fact that he is an openly homosexual judge. He's got a video on YouTube, at least one, where he's pointing out that he's out of the closet, and he's very proud of this fact that he's the only judge to be out, and talks at great length about his private sexual life. When it's common understanding, and in particular he's representing the LBGT community or GBQ community, whatever it's called, the lesbian and gay rights campaign group. And it is my understanding, it's the general understanding, that judges are supposed to be independent. They're not supposed to be batting for a particular organisation or a particular lobby group or a particular kind of anything that would be remotely political. They're supposed to be neutral. That's the essence of being a judge, that you don't have a stake in the fire, an iron in the fire, or a stake generally in issues that may come before him. And so clearly, if in my case I'm making allegations that I've been homosexually molested, that there is a glaring issue there that would make it probably unsuitable for an openly gay judge, a judge who campaigns for gay rights issues, lest he just be taking the side of the almost certainly gay police officers that molested me during my ordeals in November 2021. So that's one issue. And then there's the issue that Judge Fulford has been known to have connections, and he's not only not disputed, but he's apologised for having connections to Tom O'Carroll, who was the head of Paedophile Information Exchange, a 1970s campaign group that sought to have the age of consent lowered in terms of children, and to act as a support group for other paedophiles, and also as a forum for them exchanging inappropriate material to do with minors. So this Tom O'Carroll, who was later to be convicted for his paedophile activities for a considerable period of time in the 70s, was associated with Judge Fulford in terms of his both being a group connected to a group called the NCCL, which is a National Council for Civil Liberties, which was a group that both Tom O'Carroll and Judge Adrian Fulford, he wasn't a judge at the time, but a barrister of some sort. Since it came to light that Judge Fulford had these connections, and I think it was the Daily Mail who brought it to the attention of the wider public, and he was forced to apologise for having these connections. And I'll read a sample of an article that was produced by Joshua Rosenberg, a legal reporter, and he wrote the following. He said, this is Joshua Rosenberg talking about Adrian Fulford, he said any contribution he made would have related to concerns, this is contribution to the NCCL group, would have related to concerns about the nature of the charge of conspiracy to corrupt public morals, which could be used against a wide variety of people in potentially inappropriate ways. He added, I have always been deeply opposed to paedophilia, and I never supported the views or objectives of the paedophile information exchange. I attended this is in quotation marks now, I attended a few meetings of the NCCL's Gay Rights Committee. I remember that for a short period, Tom O'Carroll was sometimes present, which left me feeling extremely uncomfortable. In the main, I provided some legal advice in the context of general civil liberties objections to the wide-ranging charge of conspiracy to corrupt public morals. Fulford said he profoundly disagreed, in quotation marks, with those who sought an age of consent below 16. Recollecting his involvement with NCCL, now known as Liberty, he said it became apparent that for a period there was an attempt by PI to infiltrate the NCCL Gay Rights Committee, and I repeat that the attendance of any of its members at meetings caused me considerable disquiet. On reflection, open quotation marks, the NCCL Gay Rights Committee should never have allowed members of PI to attend any of its meetings, and a clear and real separation should have been created between the two organisations. I'm very sorry for what happened. I have never espoused or in any way supported the objectives of PI, the abuse of children, which I consider wholly wrong. Well, obviously, it's getting to something when a judge has to formally point out that he's against paedophilia and against abusing children. But to my eyes, and certainly what I know about Judge Fulford in relation to the appeal matter that he considered in my case, this judge, his apology is pretty hollow, and I think there's a lot more fire to the smoke than Joshua Rosenberg is prepared to let on. Bearing in mind that Joshua Rosenberg is writing for The Guardian. The Guardian is very left wing, and there's no dispute that Adrian Fulford is very much off the left wing camp, and there's no pun intended there. But the fact that he would have known what Tom O'Carroll stood for when he was sitting on a committee with him and campaigning together for rights generally and surrounding, and it was very loose terminology, campaign against a law that was going to make corrupting public morals illegal. I can't pretend to know much about what that law was or what the campaign involved generally, but there's no dispute that it involved having Tom O'Carroll attending, and Tom O'Carroll was known at the time. So Adrian Fulford, who's obviously nothing if not astute and intelligent and well read, would have been well aware, and he makes it clear he was well aware of what Tom O'Carroll stood for when he was joining forces with him in a campaign. And to me, that if I had known that I was even sitting on a train with somebody who advocated the kind of sickening forms of child abuse that Tom O'Carroll was advocating, I would certainly move carriages for my sake as well as his. But in terms of sitting in a committee with him, to obtain power and have influence over the government and over the general population and over the law, I don't see how Adrian Fulford has a leg to stand on by saying nothing to see here, but I'm very sorry, but nothing to see here in the general context, and claiming, I think to some extent he had amnesia and didn't fully take on board that he was who he was sharing a platform with in terms of NCCL and PI. But perhaps it would be even more concern that hopefully drives home my whole point about corruption and cronyism within the judicial system, of which I was an example. Because obviously now we see that because apart from anything else, the press and presumably to some extent the police would have some, and certainly those who appoint judges would have some some eye on the amount of pressure they can have to bring to bear on Adrian Fulford in terms of stuff that they may know about him. There may be more about his connections to Pi and Tom O'Carroll than we know, and that has been released to the public, and that Adrian Fulford has relied on, but other people do, and I'm sure that may well apply to other judges as well. It gives leverage to the CPS and the police to get a certain result. And it all, but in any event, it certainly Adrian Fulford is advertising his political position on advocacy about gay rights to the extent that judges who are actually sitting as judges are going live, going on YouTube channels and social media, blathering on about their private sexual life, which he may think or others may think is wonderfully progressive and so forth, but I'm not very interested in the sexual lives of members of the public generally, or public officers generally, and certainly not when it's a judge who's involved in my case who is advertising the fact that he's very much has an agenda on issues of homosexuality, and to some extent, at least, with wholly criminal and unpleasant forms of sexuality, such as PI, paedophile information exchange. But to make my point perhaps even more stark, hopefully I've made my point generally with the video and the evidence that I provided of corruption and collusion in the offences I've outlined in these documentaries. But in terms of just to finish off the documentary series in terms of Barbarians at the Gate, here's a further article. This one is from the Mail Online, and this deals with the fact that only a month after after Lord Justice Fulford had come clean about his involvement with Pi and had to apologise for that, he sat on a case which involved having an appeal against sentence, I think it was, not conviction, but sentence of a man who had downloaded footage of the worst kind of paedophilia involving torture of children, among other things, and had been convicted for that conduct. And I'll tell you I'll read out some of that story from the Daily Mail, published by Darren Boyle on the 10th of April 2014. This article states, a paedophile row judge that's Judge Fulford, has sparked anger by slashing the prison sentence of a primary school deputy who hoarded films of the sadistic abuse of young children. Stephen Horn, 34, admitted viewing child pornography over 13 years and downloading 20 hours of sickening footage. He was jailed for 18 months in December and banned from having unsupervised contact with any children under 16. Horn appealed the severity of his jail term, which was reduced to 10 months by 3 High Court judges, including Lord Justice Adrian Fulford. Last month, he was forced to defend himself over historic links to the controversial paedophile information exchange. The senior judge and 2 colleagues ruled that Horn had not breached his trust as a teacher because his crimes did not involve his pupils. They also said the sexual offences prevention order, which banned him from unsupervised contact with children, was unfair. The judges also quashed the £100 victim surcharge and said it had been unlawfully imposed because some of Horn's crimes happened before it came into force. In their judgment, Judge Fulford and his 2 colleagues ruled none of the offences involved a breach of trust as a teacher. The victims were not his pupils, but identified children abused by others, and the fact that he was working with children, none of whom was assaulted by him, and none of whom was at risk of being assaulted by him, cannot, in our judgment, aggravate his offending. Well, I mean, just on a matter of basic logic, at risk of offending, how on earth can the judge know what those children were at risk of? He's not in the mind of Horne, or maybe he is more than we would like to think, because he clearly does identify strongly with paedophiles, as we've seen from his political connections to Tom O'Carroll. But the unfairness. It would be unfair to ban him from contact with children. This is a man for over 20 years was getting his rocks off, to put it in layman's terms, getting his jollies from watching children being tortured and raped and abused in God knows how many other ways. And this Judge Fulford, says it would be unfair. It's not a question of what's fair or not fair. Surely it's a question of protecting children. And if somebody has revealed that they have over 20 years been gratifying themselves through watching children being tortured, they cannot possibly, by any criteria, not be a risk to other children. In most countries, in many countries, Mr. Horne would have been castrated, but the idea that certainly in America, for instance, he would have been. It would have been the issue of fairness would have come into it. It may not be appropriate for some medical reason because he's had some hormone treatment or something, but to worry about the fairness of this man when the risk that he's posed and the harm he's inflicted by his predilection for child pornography and not just child pornography but children being tortured, because that surely is I mean, it must amount to torture in any circumstances, but to specifically enjoy children being tortured as part of your, what fulfills you as a human being, then how could that possibly ever be trustworthy again around children again? There may be some technical points about the surcharge or the whether or not he was technically abusing his position of trust. I don't know enough about the case to comment on that, but I know that no judge who has only recently or ever has had to apologise for having connections to a known paedophile who was known to be a paedophile at the time of those connections should be sitting on any case, in my view, or should be sitting as a judge at all, and certainly not on child abuse, paedophile type cases. You're obviously going to get that result if you put a judge like that on that case. It's a rubber sealed decision, just as all the decisions surrounding my case was rubber sealed from the moment Ford, effectively on orders of Judge Fulford, of Judge Blair, of Judge Lawrie, assaulted me and invaded my space, caused me terror, caused potential serious violence around other innocent parties, breached the COVID restriction, committed unbelievable perjury afterwards by claiming he was polite, and allegations stated that I had talked about your people and my people, in order to have me remanded, in order to have me falsely pursued for the charge of racially aggravated matters, albeit he didn't actually complain of any harassment, alarm, or distress. And then all the sexual assaults and abuses and kidnaps that flowed after that are all happening on the instigation of corrupt judges, of the corruption that flows downwards, literally almost like sewage, into the wider public and into every interaction I have, and not just me, because we can see that with the case of Horne and how the public are damaged by having this judge anywhere near any cases, let alone mine or Mr. Horne's, for different reasons, for the completely opposite reasons, obviously. And let me make a point about what this judge has done, because by going, if you think about it, he's gone onto the national press, making his moral positions clear. He's a bit sorry about being connected to a convicted paedophile, Tom O'Carroll, and being part of a campaign group, even when Tom Carroll was advocating at the time to lower the age of consent and for general relaxation of all types of paedophilic activities. And the fact that the judge has sort of nudged towards an apology, but Joshua Rosenberg then goes to big him up later on in the article, if you want to read the whole thing, about what a wonderful advocate he's been since then, and a great left-wing, trendy, progressive judge. That seems to be the tone of Joshua Rosenberg's puff piece. Puff piece for when the subject matter is about the judge's connections to a convicted paedophile. But if you think about it, if you're a barrister and you got a client who you want to get a reduced sentence for, and he or she has been sentenced for the sort of thing that Mr. Horn has been sentenced for, which was getting off on for 20 years on children being raped and God knows what else, then they know if you get this case before Fulford, you know what Fulford's credentials are. We know what he stands for. If we get him on, he's going to be talking about how sorry he is for you and the how unfair it would be. Never mind the children. They can if when his restraining order not to contact children expires, it's reduced to 10 years in the article. So after the 10 years are up, and then he starts abusing other children or just continues with his predilection. If he's got a predilection, there's nothing in that article about anywhere about him having shown remorse or that he's a reformed character. There's no evidence that he's not going to be a danger. Indeed, the judge preposterously makes this assertion that none of the children were at risk of being assaulted, when he can't possibly know what the children are at risk of. He's not, as I've made clear, although I accept that it's an arguable point, that he's not in the mind of Mr. Horn, so he can't know what those children were at risk of. It would seem very odd that if he was watching and getting off on child pornography in his spare time, none of those thoughts or temptations would have entered his life, his professional life involving children. I don't see that he would have been. Those distinctions can be clearly made. Indeed, the whole point of downloading or accessing or disseminating child pornography is that you are therefore participating in the abuse. You're encouraging it and giving it oxygen by having and therefore colluding in the offence. And the judge clearly doesn't understand that when he talks about the risk aspect. But in any event, the point that I'm getting to is that he's advertising his wares. He's selling himself as a type of judge that if the barrister knows, if they can have a word with the listings officer, and believe you me, because we can see from Belden's case, what did Belden do? The registrar, Alex Belden, when I wrote to her several times trying to ensure that I had an independent judge that had no shady connections to paedophiles, that didn't have wasn't banging some drums about letting it all hang out in terms of homosexual activities, to the extent that he's banging on about his private sexual life online with a very clear-cut agenda. That's quite clear that rather than and Lord Justices don't usually decide the decision on paper. That's usually a Mr. or Miss Justice, or even a barrister that is promoted to the level of a justice to ensure, and part of the process is to ensure independence, because you should have in theory you should have a taxi rank system where you get whatever judge comes up on a system. But Belden clearly pulled strings and ensured that the most unsuitable, with the grottiest, shadiest background past, with a clear agenda that well exceeds his supposed position as a neutral, independent judge, was appointed. And for the same reason, if you've got a barrister who you want to get a nice soft touch for, if a client is up for paedophilia or some sexual child sex offence, or any probably sexual offence, given what we know about Fulford, but certainly in terms of the paedophilic issue, we know that he's a soft touch because we know that he's connected to Tom O'Carroll, and we know about his sentence for Mr. Horn. So it's actually it's in the same way that if you go to a shop and a shop sets out their wares and they try and you have advertising, like you do in commercials, and you try and sell a particular product and outbid your other customers. That's what Fulford's doing. He's setting out his stall. He's saying, this is the kind of judge I am. I'm a bit dodgy. I've got connections to a paedophile, but I'm also a campaign for relaxed morals generally. I didn't want this law about inciting immorality amongst the public or whatever it was. I've got connections to a convicted paedophile, and I've apologised for that a little bit. And look at the kind of sentences I give people like Horn, and I care about their rights and about what's unfair on them, even at the expense of clearly putting children at risk by any criteria. That reduction in the restraining order to just 10 years rather than for life as it was imposed originally, cannot by any measure not be putting children who would otherwise not be at risk, bearing in mind, there's at least one that is at risk to the public, and you want to keep an eye on when set against the difficulty it is in keeping tabs on those who have haven't come before the authorities in the past. So that really is the icing on the cake in terms of everything I hope that I've needed to say and needed to provide in terms of evidence proving that I and the general public are the victims of the most horrendous and sickening crimes in terms of the corruption within the judiciary.